Good morning, everybody. Happy Friday. Welcome to the Courtroom Files Live. We're going to start our day with Judge Middleton. He is dealing right now with an 18-year-old who has a bunch of traffic violations, including, unfortunately, a drunk driving.
It already is suspended, but this will make it even harder for you to get your license back. Do you understand?
Yes, sir.
Other than this plea agreement where we're pleading to some cases and dismissing other cases, did anyone promise you anything?
No, sir.
Or threaten you to get you to plead to this?
No, sir.
Do you understand that if you do plead to this charge, you'll be giving up your right to have a trial in front of a judge or jury?
Yes, sir.
If you had a trial, you'd have the right to be represented by an attorney. You've actually got two attorneys. Ms. Yancey's representing you in one case, and Mr. Felt is representing you in the two new cases. So you could have one appointed or you could hire one, and you've actually done both. Either way, in any proceedings, you'd have a right to have a lawyer with you. If you had a trial, you'd have the right to take the witness stand and testify on your own behalf. Everybody scoot over. But you don't have to, because you have a right not to testify. And if you did not wish to testify, the judge or jury could not hold your silence against you. And you have the right to be presumed innocent, unless the state was able to prove your guilt beyond a reasonable doubt. You understand all that?
Yes, sir.
All right. Were you driving a car on February 28th on Indian Prairie Road at about 8:30 in the morning?
Yes, sir.
Where were you going?
Work.
Where do you work?
Middlebury and Myers Distribution Center.
Yes, I knew that. Now that was 8:47. Let's see what time the other ticket was.
I think Your Honor, it was about 2:49 a.m.
Yeah, that was 2 a.m. Maybe he was coming home. I don't know what he was doing. Okay, Jordan, would you join us? I'll accept your plea to the driving suspended. So I'm going to do the sentence in that case, but it's also time for the sentencing in your drinking driving case. That's the one that Ms. Yancey represents you on. The facts in that case are not good, to put it mildly. Mr. Matt Huff is here from the probation department, and he prepared the screening report in that case, and it's ready for sentencing today. Mr. Felt is not representing you in that case. He's representing you in the new case. So we'll do Ms. Harden's case, and we'll do yours. Ms. Harden, what would you like me to know regarding that impaired driving case?
Your Honor, as the court's aware, Mr. Huff did provide a comprehensive substance abuse assessment report highlighting kind of what's been going on in Mr. Padilla's life, as well as the events surrounding December night when he got into the accident. Mr. Padilla is, as the court's aware, a young man. I think he's struggling with some emotional issues that he's not properly addressing. And unfortunately, like many people, he's turning to substances for a quick fix. I do think this event was an eye-opener for him. It sounds like he's remained out of any trouble with substances. I do have that Mr. Huff is recommending probation with, it sounds like maybe a weekend in jail to be scheduled. I would ask the court to defer jail time for Mr. Padilla. He's gainfully employed and has been throughout the case. He has family.
Jordan, you're kind of breaking up a little bit.
I'm sorry, Your Honor. I am not having a very good time with my internet today. Mr. Padilla has strong family support. His mother has been at every court date with him. I believe she's helping him with transportation. Obviously, between this case and Mr. Felt's case, license issues, he's going to have to kind of wait and see when he's eligible to retain driving privileges. So I would ask the court to consider deferral of all jail time and monitor of probation and allow him the opportunity to explore resources through that probation to address the situation. Thank you.
All right, I think we got most of that. Mr. Huff, I'll let you speak and then we'll hear from Mr. Padilla. As Jordan said, you did a comprehensive report on this. This is a troubling case, and we've bumped it back a couple of times. Is there anything else you'd like to address?
Yes, Your Honor. Just to rehash and refresh the case facts in this situation. As you've already said, this is a bad case. Mr. Padilla is only 18 years old. He does live in Sturgis. And as he stated on the record just prior, he works at the Meyer Distribution Center in Middlebury. He told me he works, starts at 9 and that he works approximately 10 to 12 hours a day, Monday through Friday. Obviously due to his age, and when we start talking about substance abuse, the fact that he's using alcohol prior to 21 automatically by status means that he's abusing alcohol. He says he doesn't drink alcohol very often. And then I asked him about marijuana. He indicated he smokes marijuana pretty much whenever he's not at work. So he's a frequent user of marijuana. Again, underage use, a concern for substance abuse. I don't know if he couldn't recall the events of this night because he was blacked out drunk, or if he didn't want to basically discuss case facts that maybe would make his situation look worse. I don't know the answer to that question, but he says he was wasted. He can't remember what's going on. So again, that is another concerning issue for, or a red flag, so to speak, for potential substance abuse or substance abuse problem. The case facts themselves are about as aggravated as you can get. Twice the legal limit almost, and that was an hour after he was stopped, or rather he got into the accident. So he's about twice the legal limit, drinking in the vehicle with passengers without a valid license when he was at fault in an accident, struck another vehicle. Thankfully, no one was hurt in the other vehicle or in his vehicle. And he was respectful with the officer, although he didn't really want to answer any of the questions. And he eventually denied the blood draw, which the officer had to apply for a search warrant in order to get his blood. I don't know that he has the ability or is at the point in his life where he's able to understand the gravity of this sort of a mistake. And then we see the driving while license suspended charges that come after this, which are essentially bond violations because he's not supposed to be being convicted of any new criminal offense. He's speeding around at 2:49 in the morning, a couple of months after he gets pulled over for this. Extremely concerning. And given his age, despite the bad case facts, my inclination was to try to work with him on a probation. I don't like the idea of throwing somebody in jail and then also throwing away the key, especially at this age, especially this is his first criminal history. But when I talked to him about probation, I mean, it really just got the sense he doesn't want to go to jail. He's got a good job. He wants to keep his job. He's not going to have a license anytime in the future. It's just the way the Secretary of State's set up. And the court's familiar with how hard it is once you go on this driving while license suspended merry-go-round, so to speak, and you have a drunk driving offense in there, and you never had your graduated license to begin with, it's going to be extremely difficult for him to get back and forth. So I hesitated even on making the probation recommendation, and I think the court would be justified if they went either way. However, I'm willing to work with Mr. Padilla again. Due to his age, I think we got to try something to try to correct this, because if we don't, he'll be back. In my screening report, I mentioned that we have a string of these cases, young men, 18 to 20 years old, not even 21, and they get a drunk driving. Within the next year or two, they come back, they get another drunk driving. And I hope that Mr. Padilla is not in that case. I think the only way we have a shot at even mitigating that risk is if we try a probation. I think that pretty much covers everything from my perspective on Mr. Padilla's case here today.
Mr. Padilla, is there anything you want to tell me?
No,
All right. Well, he also admitted to careless. I'm going to reduce that fine to $100.
Your Honor, I have two observations, if I may, as allocution.
All right,
If you're comfortable, you don't need it, I can
All right.
manage
Well,
to be quiet.
I'm willing to hear your words of wisdom. I'm going to do a $100 fine on the careless. Also do June 2nd. It's usually 175. Mr. Felt, what's your thought?
Well, two separate matters. One is, I want to apologize to the court for the scheduling snafus. I think something got lost in the translation, no pun intended. When I first met with Anthony, though, he was scheduled for sentencing. And at that time, we agreed, Attorney Harden had already resolved the drinking and driving case. There was no need for me to get involved. He was simply going to go forward with sentencing on that. What I told him at the same time was I was not available for court that upcoming date. So because of that, I told him at the moment I wasn't going to appear or be retained on the 2025 cases. I explained to him how to try to get them settled at the court hearing and hopefully get everything disposed of. So that's what was supposed to happen back then. Unfortunately, as I say, somehow in the translation, everything got adjourned and here we are. So I apologize for that. It just happened. Now,
That's all right. We're taking a block of time in the middle of pretrial time, but
yeah,
that's all right. We'll
And-
get this resolved.
and you've always been very tolerant about that and I appreciate it. The more important issue. I talked with Anthony at length in my office. I'm no therapist, obviously, but I can recognize the obvious now and then. And what we talked about simply was for Anthony, he's allowing his history to get in his way. More importantly, he's allowing it to define him. He's got an unfortunate family history that includes his brother committing suicide. And it's had a devastating effect on a few years ago. It's had a devastating effect on Anthony. But more to the point, it's to some extent beginning to define him. And we talked about that quite a bit. And I would say to you, I think he's actually ready to turn the corner here. Aren't you, Anthony?
Yes, sir.
He's ready and willing to try to turn the corner. And I think the best thing could happen to him in helping him in that regard is a period of probation for the supervision and encouragement. So we appreciate Matt Huff's willingness to be involved to that extent. If you think he needs jail time to get his attention, well, so be it, he'll do it. I say to the court, I think you've gotten his attention, but whatever you deem necessary is great. The other point is third, I guess, is when it's time, I'm going to help him get his driver's license.
It may be a while.
And it may be a while.
All right, we're gonna do both of these. Matt Huff hit some of the high points. This ticket. Tells some of the story. It's 6:15 a.m. You're driving your Jeep with a bunch of kids in it on M60 and M66 and Bojan Road, just south of Sturgis. It's a busy intersection. Your blood alcohol is more than 2 times the legal limit. You got a car full of kids. You're drunk. You don't have a valid driver's license. And you pull a Yui in the middle of a street and crash into some lady who's driving her car, nearly killing yourself, her, and everybody in your car. Then you're like in la la land when you're talking to the police. What Matt calls it is selective memory of things. This would have been a horrible headline. 7 people killed in early morning traffic accident a few days before Christmas. I guess it was actually at 4:43. I don't believe Mr. Padilla is able to grasp the severity of this offense. He didn't display any remorse. When I spoke to him about the fact the other driver was evaluated by medical personnel, he asked about the consequences in terms of jail, probation, or otherwise. I don't know what happened to the other person or anybody else. But this would be OUIL causing a serious injury, which is a 5-year felony. OUIL causing death is a form of murder. It's a manslaughter charge. Then you're still driving anyway at 2 o'clock in the morning in February, and then you drive again 10 days later, 11 days later, again with a suspended license. I think the second one you were going to work. I don't know what you were doing on the first one. You can't drive. You don't have a license. The privileges you have are suspended. You've been a Michigan resident all your life. I'm not sure how you got an Indiana temporary permit some time ago, but according to the report, you went to Sturgis High School and you lived in Sturgis. So your privileges in Michigan are suspended now at the time of this incident. And as Matt said, and Jordan said, we've seen a lot of these. I had a kid the other day who was driving drunk with a bong between his legs. He hit a traffic pole and he's wedged in the car, and the other kid is wedged in the car, and the kid calls, the passenger calls while he's wedged in the car. We almost had 2 more young Sturgis men die. Anyway, Mr. Felt's right. I need to get your attention. I'm not putting you on probation. You're not ready to do it yet. I'm going to order 3 days in jail. Credit 1. You're going to jail right now. It's Friday. You got 2 more jail days to do. There's a $300 fine, $75 crime victims' rights fee, a $50 state minimum fee, $100 screening fee, $150 attorney fee. Drinking, driving is expensive. Matt, what was the police reimbursement?
$255, St. Joseph County Sheriff's Department.
And I'm going to do the victim impact panel, which is $32. I'm not doing a probation. One fear or perhaps prediction is I'm going to see you again before you're 19, and we'll try it then, but you're not ready to make the changes you need to make. Now, you don't drive here to court. Your mother brings you every time, and I do appreciate that. Whatever car you got, sell it. Park it. You can't drive it. $300 fine, $125 in costs, $100 screening fee, $255 police reimbursement. There was an accident and a blood draw, and a $32 victim impact panel. That comes out to $812. I'm not sure if that's right. They add it again. 300 plus 125 plus 100 plus 150 plus 255 plus 32. 962. I think I left out the attorney fee. I'll give you some time to pay that. I'll make that due by August 30th. In the driving suspended case, I'm going to give you the same 2 days of jail. Zero fine, 2 days jail, credit 0. They do 2 days to serve concurrent with the drinking driving case. We've been very lucky this last from fall to now with the number of bad accidents we've had with young drunk drivers. We have enough fatal accidents as it is. We don't need to add a few more. All right, Mr. Padilla, you're going to go to jail for the weekend, and you can think about not doing this anymore. You know, $962 to by August 30th. I'm saying I hope I don't see you again soon. There's another friend in the back row. I keep seeing him and I wish he would quit coming back.
Thank you, Your Honor.
All right, Mr. Padilla, ma'am, you think about not doing this anymore and I won't have to see you anymore. And for the rest of you, we stuck that in the middle of pretrial morning. It took about a half an hour, so I guess it could have been worse.
Thank you.
Thank you, Ms. Harden. You can
Thank you, Your Honor.
get back to it.
Alrighty, good morning, everybody. Welcome again to the Courtroom Files Live. Happy Friday. For those of you who came in while this was going on, this was an 18-year-old kid in front of him, and he just got sentenced on a drunk driving, but he had other things going on top of it, including while that drunk driving was pending, a couple of driving while suspendeds. He had some other traffic violations. He's kind of a mess already at 18. I hope for his sake he finds a way to get it together, because that is not getting life off to a good start at all. Ashley, I watched the video on the court-appointed lawyers. Really helped. Thank you. I'm glad it helped. Very good. For those of you who don't know what I'm referring to, we had some discussion yesterday about public defenders, court-appointed attorneys, so I directed people to check out a video that we posted on that on the channel. It has more to do with the eligibility for a public defender, but it also explains how the public defender system works. So if you haven't checked that out, if you're curious about how that system works, go find that video. Let's change it up, and this is Judge Tony Flores, Ingham County. So we're moving in the Lansing area, just a little bit north of Judge Middleton, and let's see what's going on there.
01122, Mr. Trescone or Ms. Johnson?
No, Your Honor. And Mr. Comorn, just for your note, just so you know, I'll get discovery out on Monday. The flash drive is ready. I just want to give it one final review.
Okay.
Perfect. Anything else for the court, Mr.
Clarification. Just, can we appear by Zoom on the 30th? Obviously, we'll be in person for the exam if it's held.
Correct.
Is that okay?
For the probable cause
Okay.
conference, you
Thank you.
can appear by Zoom without objection, Mr. Trescone, as Zoom is appropriate.
Yes, that's fine, Your Honor.
All right. And on June 12th, we'll have to be live in person, but we'll see if we need that date on that at that time. Anything else, Mr. Comorn?
Nothing, Judge. Thank you for your time.
All right.
today.
We'll see everybody. We'll see everybody on May 30th live via Zoom at 8:30. Zoom is appropriate, and then we'll see if we need the June 12th date for preliminary examination. Thank you, everybody, for your appearance today.
Thank you.
Thank you, Your Honor.
Well, that looked much more interesting when I switched there, and now all of a sudden it's views of cabinets and empty tables. Let's go to Judge Meinecke. We'll head east now.
You can also Google Smart Recovery, and there's even online meetings that are available for you. But you need to be going 3 times a week to supplement your counseling. I will say that's important because Mr. Stammel is trying to do a really difficult task, and that is to get the prosecutor to be willing to consider getting you into a sobriety court program, getting you a charge reduction, and the more you can give him as far as demonstration of a commitment to sobriety, it's only going to put him in a better position. Fair, Mr. Stammel?
100%, Your Honor.
So I'm going to require the counseling 3 times a month, which you're already doing. I'm also going to, so you can't stop now. Now that you're doing it, Now you don't have the ability to stop. You got to do it to stay in compliance with my bond. But then you need to go to support group meetings 3 times a week. If you cannot find the app,
I have it here. I have it.
you got it?
Mhm.
Okay, good. So that will help you find something that's close by. When we talk again, at our next probable cause conference, I'm going to ask you if you've been going. Got it?
Okay.
All right, Mr. Stamos, the 6th work for you?
Yes, it's a good date. Thank you.
Okay, I'll see everybody back here on June 6th at 8:31 a.m. I would suggest, Ms. Calvert, that you keep track of all the meetings you're going to and get them to Mr. Stammel so that when he makes his request to the prosecutor, he can say, here's the proof of the meetings she's doing. Got it?
Okay. Thank you so much.
All right,
Thank you
good
so
luck.
much, Your Honor.
Take
Very
care.
much appreciated. Thanks.
Bailey, Meinecke does both. I want to be able to cover him in his courtroom, but I don't because the audio inside of his courtroom is abysmal. I really, really want to watch some of his sobriety court, because he's one of the few that actually streams it, and it's good, but the audio is just absolutely abysmal when he's inside the courtroom. So he does both, but you can't hardly hear anything when he's in the court.
Mr. Hilgendorf, do you need to meet with the prosecutor?
Yes, could I speak with her very briefly?
Yes. Mr. Abdo, you have Brown?
Yes, and we reach resolution.
Okay, is your client gonna come in?
I hope so. I know I'm a little bit early, so I'll call him.
Yeah, if you give him a call, I mean, I'm ready to go now, so.
Sounds like I'll give him a call.
All right, and then Mr. Hilgendorf, room 1.
Thank you.
Mr. Rosenau, the Bragg was a waiver and Calvert was adjourned to the 6th.
Okay. Thank you, Judge.
Okie dokie, and all of a sudden they've gone quiet. There's a lot of that going on today as I've been watching courts even before the stream. A lot of in and out with people. Let's, Burnett County, Wisconsin, let's try Judge Mogan.
We have Ms. Ryman Schneider appearing by video conferencing in custody in Burnett County Jail. We have her counsel, Adam Benson, by video. We're set to date in this matter for a return on warrant. Warrant is now quashed. Ms. Ryman Schneider was on a $250 cash bond. She failed to appear at her preliminary hearing on December 5th, 2025. The court issued, or it's 2024, the court issued a body only warrant. She has now been picked up and we need to set bail. Mr. Schmidt, argument.
She only has one other case in Wisconsin. It was a drug delivery case in 2009. And that one, she made all court on a signature bond. It's problematic when people fail to appear in general. It's especially problematic when people fail to appear at a hearing where an officer has come to testify. I think doubling it to 500 would be appropriate, especially given these are not victim crimes.
All right, Mr. Benson, argument.
Thank you, Your Honor. I'm uncertain of Ms. Ryman Schneider's ability to pay. Her husband had contacted me a few days ago before she was picked up, and we were going to attempt to bring her in. I had a letter scheduled to go to you yesterday about that. CCAP went down and she had been picked up. If she can't pay the 500, I would ask it to stay at 250 for her to come up with that again. It's my understanding that her husband's also working on inpatient treatment at this time, and that if she is held in jail, that she could be released for that option.
Well, this has been a long time since the warrant has been issued, since December 2024. It is now May 2nd, 2025. The court has had no contact with Ms. Ryman-Schneider since the court issued the warrant. The court is going to increase the cash to $500 cash, same conditions as previous bond. If she is unable to post after some time, she can request to have a bond modification hearing and we can go from there. We do need to set this matter for a preliminary hearing. Mr. Benson, I can do it as early as May 14th at 9:30.
That works for me, Your Honor.
May 14th at 9:30. We will see you then.
Thank you.
We are adjourned. Mr. Chapman? Oh, I do not yet have, sorry. I do not yet have Mr. Marco, but once we do, we will be ready to go. I do have Mr. Repka right here. So as soon as we have Mr. Marco.
Morning, Your Honors.
And while she's waiting for all of the participants, let's go back to Judge Meinecke, who is back moving again.
Ms. Littleton is going to be pleading guilty to count 1, OWI, and I believe the people are dismissing count 2.
That's correct, Your Honor.
We would ask for a Cobb's to probation if that's possible. She has no record.
She's in full compliance with her bond, from what I can tell. As long as that remains the case, the court will give a Cobb's to probation. So what that means, Ms. Littleton, is a Cobb's agreement is an agreement between you and I. You offer the plea, and I indicate that I'm going to give you a probationary sentence. Now, you can secure that by making sure that you are in full compliance with bond. Like if you miss tests, if you test positive, things like that, then this agreement goes off the table, and the court can still sentence you to jail. I may not. Mr. Hilgendorf will certainly make arguments to the contrary, but you won't have the guarantee like you're going to get if you stay in compliance with bond. Do you understand that?
Yes.
Okay. All right. With that being said, please raise your right hand. Swear to tell the truth, the whole truth, and nothing but the truth, so help you God.
Yes.
All right, please put your hand down. All right, Miss Littleton, can you read, write, and understand the English language?
Yes.
Can you hear and understand me?
Yes.
Have you had a full chance to discuss this with your attorney?
Yes.
Are you satisfied with your attorney's advice?
Yes.
All right, you're pleading guilty to operating while intoxicated. That's a misdemeanor charge, carrying with it a maximum possible fine of $500 plus costs and up to 93 days in jail, all at this court's discretion. You also have a hard suspension of your license for 30 days. Before you enter a plea, you should understand you have the right to represent yourself or be represented by an attorney. If you cannot afford an attorney, one to be appointed for you at public expense. You have the right to a trial, either by me or by a jury. At that trial, you'd have the right to confront, cross-examine, question all witnesses brought against you. You'd have the right to have the court subpoena witnesses on your behalf. You'd have the right to testify if you wanted to, remain silent if you wanted to, and no one could say anything about you remaining silent. As you appear before this court, you're presumed innocent of this charge, and your guilt has to be proven beyond a reasonable doubt. Miss Littleton, do you understand that once you enter a plea, you give up all those rights that I just said that you have at a trial?
Yes.
Once you plead guilty, there'll be no trial. You understand that?
Yes.
Has anyone promised you or threatened you in any way other than, 1, the prosecutor dismissing count 2, and 2, this court indicating that I would give you a probation sentence as long as you follow my bond conditions? Other than those promises, anybody else promise you anything?
No.
Anybody threaten you?
No.
It's your own choice to do this?
Yes.
All right, directing your attention to November 13th of last year, 2024. Were you operating a motor vehicle in the area of 696 in the city of Royal Oak?
Yes.
Were you stopped by the Michigan State Police?
Yes.
And did they have you at some point in time step out of your vehicle, do field sobriety tests?
Yes.
And then were you placed under arrest?
Yes.
Transported back to the Metro North Post, Michigan State Police?
Yes.
And did they have you do a breath test there?
Yes.
And counsel, for purposes of this plea, stipulate to a .163 and .159?
Yes, Your Honor.
All right, Miss Littleton, what did you drink to get to that bodily alcohol content? Was it beer, wine, liquor? What was it?
I had a couple cocktails and also a couple shots.
Okay. Looking back on it now, with the benefit of hindsight, would you agree that your ability to operate that vehicle in a normal manner was substantially affected by your consumption of alcohol?
Yes.
Satisfied, Mr. Hildendorf?
Satisfied.
I too am satisfied the plea is knowing, voluntary, and accurate. I will accept the same. So this happened when Miss Littleton was just a few months 21, right?
Yes.
Okay. So, Miss Littleton, we've got to figure this out. That's quite a start to your adult career. This is a big charge to try to manage. Now, if we get this done the right way, and I expect that we will, then you'll be in a position to move forward with your life and not be in this situation ever again. But what we want to do is to make sure that we take this very, very seriously. Getting Mr. Hildendorf involved shows me that you're taking it seriously. Staying on track of your testing shows me you're taking it seriously. So that's what we got to do. We don't want to minimize this or make light of it. We want to get to work and figure this out. My staff will be in touch with you and your attorney. They'll set up an interview. The interview will be on Zoom like you and I are talking right now. The probation officer will ask you some questions, get some basic background information, and they'll prepare a report that you and Mr. Hildendorf will get to see in advance, and it'll list out all of the recommendations. And when you come back and see me, then we'll go through at sentencing what your requirements are. I expect that you'll meet those and move forward with your life. Mr. Hildendorf, anything else for the record?
Nothing further. Thank you very much, Your Honor.
All right. Good luck, Miss Littleton. Good to see you, Mr. Hildendorf. Take care.
Good to see you. Have a good weekend.
Take care.
Okie dokie. Let's go over to Judge Simpson. He's doing a landlord-tenant docket, or as Judge Middleton calls it, an exercise in misery. Let's see what's going on there.
Yeah, I get my check.
Oh, okay. So the 23rd. All right. It sounds to me like something can be worked out. All right, but I'll pay the $1,600 on the 5th. I'm going to adjourn this out to my next date because of a judicial conference. Council is the 16th.
Okay.
So I'm going to adjourn it out May 16th, 2025 at 12 p.m. Okay. So make sure to get the 1,600 in, and then if there's some other funds that you have, get that paid before that date, and then we'll see where we are and what can be worked out. You can also contact counsel's office and try to work out a conditional order dismissal if you know you're going to have it on the 23rd.
Okay.
Okay.
All right. Well, thank you.
Right. Thank you.
Bye-bye.
Sile Farms versus Holly Connolly. You got him. Holly Connolly. They are not here.
Your
And
Honor,
would you like? Yes.
my client advises they received payment in full this morning, but it hasn't cleared yet. So if we could adjourn this one over to the 16th just to verify that payment. And once it's cleared, we can submit a dismissal.
Not in front. May 16th, 2025 at 12 noon. Court calls case of Sile Farms versus Nicholas Wasowski. He's here. Where? Oh, there. Okay. Hello.
Hello.
And also, I should say, Nisco Scroggins.
Hi.
Okay, they're both there. There they are. Hello. All right. How much is owing on this case?
Your Honor, total as of this morning was $3,794.67. My client did receive a partial payment of $1,800, which is being processed by Sile Farms, and so that balance will be reduced accordingly once that payment has cleared.
The payment was $1,800.
That's correct, Your Honor.
Okay, so then we'd be around a $2,000 figure, assuming that comes in. All right, so folks, how are you intending on getting the rest of this paid?
So I already have all of it paid. I actually talked to them earlier this month and paid off all of last month, and they said I had to the end of this month to pay them and we'd be good. And 7 days later, after I paid them, they filed this court thing saying I owed them from February, which, as far as I'm aware, I came to court with you for. So I have
you
no
don't
idea why we're here
hold on a
at
second.
all.
So you don't hang on a second.
Yep.
But so you realize that included in this figure that we have is your
Is this
May
month?
rent.
Yep.
Okay. So what I have as a basic distinction when I look at it is I have your May rent plus court costs basically that's owed.
Yes, effectively. But I am objecting to paying court costs because I paid them last month on the 7th. I have the receipts right here. And on the 15th of last month, they filed saying that I owe them for February.
Your Honor, if I may,
Well,
this
the
case was,
calculation of rent that's due, it's basically, and at least as I used to do it, a per diem calculation, which just comes out to a date as that you're paid through.
Got it. But I don't understand
Okay.
how. But I don't understand how I could not have paid all of February when we went to court for February.
Well,
And part
sir,
of your
sir, if you look at the complaint, it says you're paid through February.
And at the beginning of this month on the 7th, I was paid through the end of last month. I have a receipt for it right here.
I don't have that in front of me. All I know is that right now, what's owed is going to be May. What looks like is owed is May plus the court costs on this case. Now, if you're objecting to the court costs saying that you had everything paid, then I'm not sure how that's the case, given the fact that you just tendered 1,800.
So at the end of this month, or at the beginning of this month when I paid, they said that I was paid up to the end of last month. Okay. So that I tendered the excuse me. When I'm saying this month, I mean the previous month. It is now May. I have misspoken. So the end of the 3rd month, I was paid up to on the 7th of last month.
Your Honor, if I could just add a little something here. Your Honor, Mr. Lazowski and Ms. Scroggins moved into the community in October of 2024. Unfortunately, they have not paid timely or in full since then, and so there've been a rollover balance. I can understand why maybe Mr. Lazowski is confused as to how the balance is, where it's at. I urge him to get a copy of the ledger so he can see exactly.
I have a copy. I have a copy.
Mr.
of the
Lazowski,
ledger
please,
from the 7th.
please don't interrupt. I'll give you an opportunity to speak. If Mr. Lazowski reviews the ledger, Your Honor, there's been continuously a rollover balance and partial payments made toward that balance, sporadically, basically since they moved in. And so, you know, unless they're paying down to zero on time each month, it becomes difficult to understand how the balance keeps rolling over. But if they review the ledger, they'll see that their payments have been applied, and the balance that's due and owing currently after the $1,800 payment made today is applied. They'll see that the balance, as Your Honor indicated, is basically their May charges plus court costs.
Okay, so I have a question. If I owe approximately 1 month's rent as of today, and I tendered that today, and I'm caught up except for this month plus court costs, would that not mean that I would have been caught up to the end of the 3rd month before that $1,800 payment?
Oh, sir, that payment was due April 1st, and you made it on May 2nd.
Yeah, I'm aware. I went in when I went in and made that payment on April 7th. I was told in person that as long as I made the payment by the end of the month, that I'd be good.
Sir, I don't know entirely what we're arguing about. You owe May. Your only question was that you don't think that you should have to pay court costs. If I look at a ledger and at the time that the complaint was filed, you owed funds, then you're going to be liable for the court costs.
Okay. Understood.
So when are you gonna get the balance paid?
I can have it paid by the 14th. I think. Wait, let me double check account. Yeah, I can have it paid on the 15th at the latest, 16th. I get paid like 1 a.m.
15th. Here's what I'm gonna do. I'll adjourn this out May 16th, 2025, 12 noon. 12 noon. You need to have the balance paid by then. Okay? Thank
If
you.
I make the payment in full, do I need to show up for court?
You don't, if it's cleared, you don't need to show up. But
Okay.
if it's not cleared, so the earlier you get it in, the better off we are.
I apologize for my frustration. Thank you for your time as always.
Thank you.
And that court would be in person?
That is in person.
Okay, thank you.
Thank you. Scioto Farms versus David Sheldon Ball and Ivan Ball. They here? You don't have them checked in? Sheldon Ball or Ivan Ball? Ivan. Yeah. Nobody has responded. Would you like to take it?
Your Honor, in this case, we were contacted by a Richard Ball. Apparently, he is the brother of Ivan and David Shelton Ball. I've not had an opportunity yet to speak with Mr. Richard Ball, Your Honor, but the message that he left with our office is that both defendants are deceased within the last 6 months, and there's nobody residing at the home. I've not received any death certificates, Your Honor, and I would request entry of a default judgment today, but my intention is to speak with Mr. Richard Ball to ascertain what the family's intentions are with respect to the home. I do not know if there's a pending probate estate.
Good. Okay, if you'd raise your right hand, do you solemnly swear or affirm testimony you're about to give will be the truth, the whole truth, nothing but the truth, so help you God?
I do. For the record, Rachel Dornbush, Appellant's Law, on behalf of the plaintiff. Your Honor, there's rent to retain of $3,041.48, costs of $230 for a total due of $3,271.48. We'd ask for a default possession only judgment with writ to issue after 10 days.
Judgment to the plaintiff, that is by default for possession, redemption amount, any amount requested, writ to issue in 10 days. Scioto Farms versus Jesse Steinberg or Steinberg and Brent Steinberg.
Yes, sir.
Okay. Hello.
Hello.
All right. And Ms. Dornbush, what's owing on this?
With costs, Your Honor, $3,881.65.
All right. And ma'am, how is that? How do you intend on getting that paid?
Yes, sir. By the 10th of this month, it should be paid in full.
Okay. Okay, well, you're entitled to a one week adjournment. I just don't have next week because of a judicial conference. So what I'm going to do is I will adjourn this then to May 16th.
Okay, thank you.
2025 at 12? Yes. At 12 noon. Okay, get that paid, and if everything's paid, they'll likely dismiss the case.
Yes, sir. Thank you.
All right, thank you. Scioto Farms versus Jacqueline Stickney. Jacqueline Stickney, they are not checked in. You may proceed.
Thank you, Your Honor. There is rent to retain of $2,836.79, cost of $190 for a total due of $3,026.79. We'd ask for a default possession only judgment with writ to issue after 10 days.
Judgment to the plaintiff by default for possession, redemption amount, any amount requested, writ to issue in 10 days. Scioto Farms versus Rachel Tafini and Treva Fowler. Tafini, neither party is checked in. You may proceed.
Thank you, Your Honor. There is rent to retain of $2,679.53, court costs of $230 for a total due of $2,909.53. We are requesting entry of a default possession only judgment with writ to issue after the statutory 10-day period. Your Honor, my understanding is that defendants have worked something out with their lien holder to basically surrender the home to them, but there has not been a finalized move-out date. So I'll speak with my client to see if there's any way to coordinate move-out dates, even though a judgment is entering for the statutory 10-day period.
Got it. Okay, thank you. Sile Farms versus Annette Fair. Annette Thayer. They're not checked in. You may proceed.
Thank you, Your Honor. There's rent to retain of $1,064.83, cost of $190 for a total due of $1,254.83. We'd ask for a default possession only judgment with writ to issue after 10 days.
Judgment to the plaintiff by default for possession, redemption amount, any amount requested, writ issue in 10 days. Sile Farms versus Luana Tut.
Well, apparently if you live in Silo Farms, you can't afford what they're doing there, because they got everybody in court. Let's switch it up. Let's go back to Judge Middleton. FYI, if you are a Judge Fleischer fan, he is not online. I don't know if he's going to come on today or not. We'll see.
I have to segue from translator mode to regular case mode. Translator mode, you have to speak in short sentences and allow the translator to translate. It takes about 3 times as long. Then we get just back to regular old court and it goes faster. Are you Jaden Begtel?
Yes, Your Honor.
Here with your lawyer, Rhonda Ives?
Yes.
Ms. Begtel, you're charged with domestic violence. We get lots of those too. It's a misdemeanor. It's punishable by up to 93 days in jail and a fine of up to $500. Let me see if they put this in my queue. There it is. It also would prohibit you from using or possessing a firearm for at least 8 years. The allegation is that on March 21st in Mendon Township, that you assaulted Skylar Kloosterman, someone you had a dating relationship with. The prosecutor has agreed to dismiss that charge for a plea to disturbing the peace. Disturbing the peace is what I refer to as an old-fashioned simple misdemeanor, punishable by up to 90 days in jail and or a fine of up to $500. Do you understand the charge?
Yes, Your Honor.
Ms. Ives, is that your understanding of the plea agreement?
Yes, Your Honor.
All right, this happened out on Simpson Road outside of Mendon, is that correct?
Yes, Your Honor.
Whose house was that?
It was his foster's dad, Your Honor.
All right, you live in South Bend, right? Or did?
I did.
Where do you live now?
Keystone.
All right, I think you told me that when I saw you last time. So you and Skylar were sort of couch surfing at his old foster care home.
Yes, Your Honor.
And you got an argument about splitting up, and it says here you slapped him on the arm and on the face. Did you strike him?
Yes.
All right, well, you tell me what happened.
So I found out that he was cheating and everything, and I wanted to leave. And he was just telling me no. I said I have to. And then he made a fist. And that's when that happened.
Did you slap him? All right, disturbing the peace, and I say this a lot, doesn't matter who was right or wrong or who started it. Did you find this infidelity information on his phone?
Yes, Your Honor.
We got a lot of fights about stuff people find on their partner's phones. All right, they took you to jail. How long were you in jail?
12 to 13 hours.
You posted a bond on, you got arrested on 321, posted a PR bond. When I saw you earlier, you were at Keystone, so you've been there about a month now.
Yes, Your Honor.
Have you had any luck finding a place to go?
No, Your Honor.
Where's your family?
LaPorte, Your Honor.
I have my phone in my pocket for reasons I don't. Someone's calling me during court. I'll call them later. My apologies. I forgot to take it out of my pocket. I'm gonna give you a fine, but you don't really have the current ability to pay it. But I have some things I have to include. I'm gonna order 1 day jail credit, 1 day. Are you still in a relationship with this person?
Yes, Your Honor.
The next matter is People versus David Lee Jensen.
Your Honor, I've got to come back to him if you don't mind. He's in the hallway. He's got
All right,
a
that's
couple more
fine. We'll
questions.
take up some other matters here. Thank you.
Last night.
Yeah, which Mr. Engelmeyer do you have?
Kevin.
Yeah, they both got arrested. Michael and Kevin, I think. Well, I'll be right here.
Okay, thank you, Your Honor. I'll let you.
Warrant, Charles and Kevin. All right, Mr. Moore, what have you got for me?
That matters. Rebecca.
Apologies to everyone.
She indicated that is not what that's not her understanding of the bond condition.
Now remember, Rebecca Karen Bales, no drugs and no alcohol. They didn't do no contact, but they checked off, do not appear at their residence, employment, or school. No weapons, no assaultive behavior, and sign up with Community Corrections Office. So have you done that?
Yeah, I did that, but the no house and no school was not part of it.
It was her understanding that it was peaceable contact allowed. They've been living together, husband and wife. They have a family.
Who set this bond? Luke Laurie, who's not here. Well, all right, it's hard to tell.
Yeah, Ashley, Bailey, anybody else out there? We just lost power for a minute. We're back up and running now. That was what the little glitch was there. Apologies. This is such a fun little neighborhood to live in at the moment. Anyways, back to court.
No assaultive or threatening behavior. Almost universally, there's a no contact provision, but I can't tell that it was put in here. But at any rate, we're gonna set this for a final pretrial. Is that correct?
That's correct, Your Honor.
All right. That'll be set on a Thursday afternoon. And I don't yet know the date. I don't have any crime victims' rights information. I can't discern much else.
He's here.
All right. Have you met with the prosecutor?
No, I haven't.
Well, you're the complainant. I would suggest perhaps you stop this morning and ask to talk to the crime victims' rights people at the prosecutor.
I've called them twice so far, but.
Well, you're here, they're here. Why don't you take a minute and talk with them?
All right.
All right, Ms. Bales. Did I interview you for a job position one time? No. All right. Apparently, my memory's not accurate. Anyway, we'll set a date on a Thursday, but you're free to go. Continue to comply with the terms of your bond. All right, and for whatever reason, when you got arrested, they didn't fingerprint you and you slipped under our radar. So Mr. Loker, he needs to. Now, I can't tell anything about this because there's not much information in here. Let me tell you both what the plea agreement was for you to enter a plea to domestic violence. There's a special statute in the Michigan Code that allows a judge with permission of the prosecutor to take a domestic violence plea and place the person on probation. And if they successfully complete the probation, the charge would become non-public. And as a condition of probation, I would have ordered you to go to the women's domestic violence treatment class or anger management class, which is a very good class. So I don't know too much about this at this point, but I'd like you to go check in with the prosecutor's office to give your input. That may affect their decision on what to do. We'll set a final pretrial out a few weeks.
Thank you.
All right. And Mr. Moore, what's your other case?
Joseph Frederick from yesterday.
Yesterday? He was here yesterday?
No, prodigal son has returned.
Well, he wasn't. Were you here yesterday?
No.
No. Well, I don't think I have that one.
It wasn't set for today.
Oh.
There wasn't a non-appearance. We got a whole touch base with each other last night.
Oh, let me get it. Did I call you and leave a message?
Yes, you did.
All right, well, let me get the file. And see what the deal is. All right, give me a minute.
Alrighty, well, he steps away. Let's go over to Southfield, Michigan, and Judge Sheila Johnson, and we'll see what she's got going on this morning.
We just talked about so that your lawyer has time and an opportunity to try to resolve this case, at least to your benefit, with a misdemeanor. Okay, so that's a knowing voluntary waiver, which I will accept. We'll set this again. That's going to be May 30th. What time was that, Jessica? 9:30. 9:30. All right, now we'll do Bowler. Okay. Well, this is case number 24S01216FY, within Michigan versus Juwan D'Angelo Bowler.
Shockley, on behalf of the people. Randall Upshaw, on behalf of Mr. Bowler, 125, so what's state your name, Mr. Bowler?
Okay, Mr. Bowler, and good morning, Mr. Upshaw. Mr. Bowler, you're here for a probable cause conference as well on some felony charges. Count one being child sexually abusive activity. It's a 20-year felony with $100,000 fine potentially. Count two is using a computer to commit a crime. Maximum term is 20 years or $20,000, or it could be up to life apparently. And count three, another child sexually abusive material, possession of that. That's 4 years, $10,000 fine. Count four, again, using a computer to commit a crime. Maximum imprisonment here could be 4 years or more, but less than 10 years. It's technically 7 years, $5,000 fine. 5-year misdemeanor, count five is a misdemeanor. Furnishing obscenity to children, it's 90 days, $500 fine. Count six is a misdemeanor. 1 year misdemeanor with a $5,000 fine, using a computer to commit a crime. And so you have a right to have your preliminary examination on the felony matters within 21 days of arraignment and within 7 days of today's first probable cause conference. The misdemeanors are kind of just trailing along with the felonies for later disposition. So you understand that. Okay. Okay, Mr. Upshaw, do you have all the discovery that's attached to this?
I was just thinking last night.
Oh, so you have the. All right. Is there anything video?
Your Honor, this is a
Special prosecutor.
Lydia McCall.
Okay, let me make a note. You're just standing in for her today?
Correct.
So you got to contact Ms. McKell to see if there's anything else you don't have. So we'll adjourn it for review of discovery.
Court's available May 19th at 9:30.
Is that enough time for you?
Yes.
Okay. May 19th, 9:30. His bond is continued.
Your Honor, I believe that's outside of the 21 day.
Okay. So we're going to waive it. Sir, you're going to waive your right to proceed within 21 days of your arraignment and within 7 days of today. So your lawyer has the opportunity to get the information and review it himself and review it with you. Okay. So that's a knowing voluntary waiver. And then we'll keep that date May 19th for another probable cause conference. All right, he's all set. See this case now.
While she's between contestants, real quick, I had to briefly go to my backup internet during that little 30-second or so power outage. Can you just let me know in the chat if the stream is working okay now? I've got everything back to the way that it should be. I just want to make sure there's no more glitches.
Two. Anybody here on whack? Is that person in custody?
No, she's.
Okay, let's do that. Okay, it's case number 25S00373FY, State of Michigan versus McKell, MIKELL, WHACK, WHACK.
Sharply, on behalf of the people.
All right, cool. Thanks, everybody. Appreciate it.
Okay, and Ms. Wack, tell us your name. All right, and here we are for a, looks like probable cause conference. This is on one count of child abuse, 3rd degree. Maximum penalty is 2 years in prison or probation for up to 5 years. And you certainly also have a right to have a preliminary examination on this charge within 21 days of your arraignment date and within 7 days of today's date. So you understand that. Okay, so Mr. Quaz, do you have your discovery?
I have a written discovery so far in the form of an incident report. I think there maybe some medical reports that will be forthcoming, as well as some video evidence that I have yet to receive. Based upon that, we would like to have this matter set for another probable cause conference, requesting June 6th. We will waive the 21 days.
Okay, is good, June 6th good for us?
Court's available June 6th at 9:30.
All right, June the 6th, 2025, 9:30 will be the date for another probable cause conference. Ma'am, you understand you'll be waiving your right to proceed within the 21 7 days that we just talked about so that your lawyer can obtain, I guess, the medical records, any other video, review it, and then talk to you about it. Okay, so we'll go ahead and waive that 21 7 days. That's a voluntary waiver. And then we'll come back June 6th at 9:30. Okay, as far as bond, I'll continue the bond, but pretrial services says they're looking for her. They say she was supposed to contact them the following business day after April 19th. They have not contacted her. They attempted to contact her, but it's been unsuccessful. They called on April 23rd. They sent a text on April 23rd, and they sent a letter to the address on Fielding Street on April 23rd. If she doesn't contact them, they're going to close the case, and that's going to affect her ability to be free on bond. So,
Judge, I do have a contact number. Your court officer was gracious enough to provide me.
Jennifer Lechner.
Almost like it.
Okay. Did you get any of the correspondence?
My phone. So I didn't.
Well, who lives at the address that they said they sent a letter?
I live at that address.
You didn't get a letter either?
I haven't received anything, so I wasn't even aware of it.
Okay. Well, better call her now. I hope your phone's back on, and I don't understand why letters aren't working, but your bond is at stake and you don't want to risk that. Okay. So I'll make a note, send an advice to contact pretrial services today.
Thank
you. Mm-hmm. She's all set.
Thank you.
Okie dokie. A lot of the normal judges that I follow simply aren't in court today, but that's all right. It allows us to change things up a little bit and try some new things. Let's go to Clayton County, Georgia. Hold on. I don't have that quite set right. There we go. Anyways, let's go to Clayton County, Georgia. This is first appearance court, and I always find this one interesting because they line them up in the hallway and just go through them one by one. So let's spend a few minutes there.
Presiding over the matters in court today. If you're having trouble at any time hearing me, please let me know. There are a few things that we need to go over prior to starting the calendar. Please listen carefully as it will help you better understand the nature and the purpose of today's proceedings. First, we're not here to try your case, to take a plea, or have any legal discussions about your matter. The purpose of the first appearance hearing is to inform you of the charges against you, advise you of certain rights you have, set bond for those offenses for which the court is authorized to set bond, to schedule a preliminary hearing, to determine whether you require the assistance of an attorney. You have the right to remain silent. If you give up that right, anything you say may be used against you in this proceeding and will be used against you, can and will be used against you in later proceedings. So please do not attempt to tell me any specifics about your case or any legal defense you may have. During this and all other proceedings, you have also the following rights. You have the right to the presumption of innocence. You have the right to indictment by grand jury for felonies and have an accusation filed against you for misdemeanors. You have the right to a speedy and public trial. You have the right to compel the attendance of witnesses to testify on your behalf. You have the right to see, hear, and question witnesses who are called to testify against you. You have the right to testify on your own behalf and offer evidence in your own defense. You have the right to have an attorney represent you. If you cannot afford to hire an attorney, one can be appointed to represent you. Also, if you are not a citizen, some charges may adversely affect your immigration status. You will need to consult with an attorney. Some of you will be allowed to post unrestricted bonds for your release from jail pending the prosecution of your case. These bonds may be posted in one of three ways: by cash, commercial, or property bond. If you post a cash bond, someone will deliver the full amount of the bond in cash together with any mandated fees to the sheriff's office, who will hold it until your final court date, at which time the cash will be returned to the person who posted the bond. If you do not have the full amount of the bond in cash, you can use a commercial bonding company who may take up to 15% of the amount of the bond as their fee, but this fee will not be returned to you. You may also have someone post a property bond as long as there is net equity in the property of at least 3 times the amount of the bond. For example, if I set a bond for $2,000, your property must have at least $6,000 in equity to qualify as a property bond. Each of you will have as a condition of your bond that you are not to violate any laws while out on bond. Some of you will have an additional special condition that prohibits you from contacting certain people or going to certain places. If you have a no contact provision on your bond, this means you must stay away and have no contact with the victim. You may not call, text, email, write a letter, or contact them through any social media platform. You can't even do something nice for that person, such as sending them flowers, a gift, or a nice song. As nice as that may be, it will be a violation of your bond. If I order you to not return to a particular location, that means you cannot go back to that location for any reason. If the no return to location is a shared residence, meaning you reside there with the alleged victim, please let me know and I will authorize you to go back. Is everything okay? Are y'all able to hear me?
I got it. Hello? Yes.
Yes. Okay. Again, if the no return to location is as a shared residence, meaning you reside there with the alleged victim, please let me know and I will authorize you to go back, but only while you are accompanied by a sheriff to collect some of your personal belongings that are not in dispute, meaning that there is no issue with who owns the property. You will need to make an appointment with the sheriff's office within 10 days of being released to pick up your personal belongings. Now, unfortunately, some percentage of you will be back in custody on a bond revocation because you didn't take what I'm saying seriously. Instead, you will try to return to the residence or try to reconcile with the victim. The moment the victim becomes upset, the police will be called and you'll be arrested and held with no bond. The court takes these special conditions very seriously. Please follow the order until it is modified or your case is resolved. If you do violate the bond order and the court considers your contact intimidating or harassing, you could receive additional felony charges such as aggravated stalking or influencing a witness. These type charges carry punishment of up to 20 years in prison and $20,000 in fines. Also, if your spouse or family member or friend is the alleged victim in your case, he or she will not be allowed to post bond, nor are you able to contact the victim while you are in jail. Some of you are charged with offenses for which this court is not authorized by law to set bail. In this event, a bond hearing will be scheduled before a judge of the Superior Court of Clayton County. If you're currently on active probation, this court is not authorized to set bond at this time. Whether a bond is appropriate in your case will be reconsidered after the probation officer has had an opportunity to consider your new arrest. Please listen carefully as I talk to you about the preliminary hearing. Today, I will give each of you a date for your preliminary hearing. The purpose of the preliminary hearing is to determine whether there is enough evidence or probable cause to keep you detained on your charges. If you bond out, your preliminary hearing is automatically waived because you are out on bail and you are no longer detained. If you are charged with a misdemeanor only, when you come up before the court, I will ask you if you wish to waive your preliminary hearing. Waiving your preliminary hearing does not affect your rights or your bond amount. It simply moves your case from magistrate court to state court faster. The court does not have any preference as to whether you waive your preliminary hearing. However, when I ask you if you wish to waive your preliminary hearing, if you respond by asking what does that mean, I will just go ahead and set your preliminary hearing, as I do not want you to waive something that you do not understand. Also, if you have a prior criminal history, meaning this is not your first arrest, you are not eligible for an OR or a signature bond. Please listen to this warning. It has come to our attention that inmate families have been contacted by individuals claiming to be an employee of the jail, offering a pretrial program and dismissal of all charges if a substantial fee is paid. Please note that this is a scam and no such program exists from the jail. Finally, I'm about to read to you the oath. If you understand and swear to this, please respond, I do. Everyone, please raise your right hand.
Raise the right hand. Everybody raise their right hand.
Do you swear or affirm that the information you give today and on your court-appointed counsel form is true and correct? If so, say I do.
I do.
All right, you may put your hands down. All right, we can get started.
All right, Your Honor. We were gonna go ahead and go with the females, and then if the interpreters come in, we'll just implement the Spanish and the Chinese interpreter.
All right. That's fine.
Okay.
Okay.
Okay, time to vote. Our friend Judge Fleischer is now online. We can stick with this brand new thing, or we can go see Judge Fleischer. Put a 1 in the chat for Fleischer, put a 2 in the chat to stick here. You have 30 seconds. Go.
Morning. What's your name?
Sorry. I'm sorry. My apologies, Your Honor. I have an issue with drugs. We have a male and a female that's been in the first appearance of last
I'm sorry, say that again.
I haven't had a female come to first appearance for the last 4 days. Haven't had any paperwork on her. And she had, I guess, a co-defendant come in with her. He got charged yesterday. He's back up now.
Okay, so I think we have that taken care of. You can just bring them up, okay?
Okay, I'll bring them up later.
Okay, what's your name? Okay, y'all are breaking up a little bit. What's your name?
Jessica Quinetta Love.
Okay.
Is it still breaking up? The internet connection is us right now. Is that better?
Okay, Ms. Love, you've been charged with battery, family violence. Your bond is
How weird. People want to see Judge Fleischer. I never could have guessed that. Here we go.
Protective order, the state can and probably will file additional cases against you. Violation of protective order. It's one of the worst cases you can pick up. So know what you can and can't do. You've got a great lawyer here. Listen to him and he will take care of you. Because you have a lawyer, I will waive your appearance. You don't have to waste your time coming to court, but you must stay in touch with him and he'll tell you if and when you have to come back to court. For now, we will have you go to Victoria, sign a reset. You will then take a seat in the jury box while we get your bond conditions. We'll have you sign it and then you'll be free to go.
Thank you, Your Honor.
Guys. So can you file no contact, no weapons on both of the cases, please?
Judge, next is case 13. Martinez, come on up.
Morning, Judge.
Mr. Butler.
Like you're ready to deal some cards.
That's right. Always a pleasure. How are you, man? So you are Miss Martinez. Miss Martinez, you're charged with driving while intoxicated. You're facing up to 6 months in jail and or a $2,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you, man. Okay.
Thank you, Judge. On April 26, 2025, a law enforcement officer observed a motor vehicle fail to slow down as it crossed train tracks, causing all 4 tires to come off the ground and the vehicle to go airborne. The law enforcement officer observed the motor vehicle land, lose control, and nearly crash. A traffic stop was conducted. The law enforcement officer contacted the driver and the sole occupant of the motor vehicle, who he observed to have glossy eyes and a strong odor of alcoholic beverage emitting from her breath. The defendant stated she was just at a bar called the Sugar Room. The defendant stated she had 3 alcoholic beverages. The defendant stated she had chronic back pain, but was willing to perform the standard field sobriety tests. A 6 out of 6 was recorded on the HGM, a 4 out of 8 on the walk and turn, a 3 out of 4 on the one-leg stand. The law enforcement officer observed a receipt in the defendant's purse showing she had purchased 8 alcoholic beverages throughout the night. The defendant refused breath. A blood warrant was signed and executed.
Okay. Any prior DWI? Okay.
So, Your Honor, there's no traffic offense stated. He claims that the car went airborne, all dukes of hazard.
Sure.
Yet there's no evidence to support that. I mean, did all wheels come off?
This is a probable cause hearing, right? We're not going to get evidence at this point. You know, I think that there's sufficient probable cause to go forward. Now, it doesn't mean you're guilty, but it's enough to go forward for now. Ms. Martinez, I am going to find that there's sufficient probable cause, and I am ordering you as a condition of your bond not to consume alcohol, illegal drugs, unprescribed controlled medication. I'm going to randomly test you. If I find that you're using, we will revoke your bond, put you in jail. No more PR. You understand? Because you have a lawyer, we will waive your appearance. You don't need to waste your time coming to court, but you must stay in touch with Mr. Butler, and he'll tell you when you have to come back to court. For now, we'll have you go to Victoria, sign a reset. We'll have you take a seat in the jury box while you get to pretrial services, sign your documents, and then you.
All right, appreciate it.
Counsel, was it Marshall?
Yes.
All right, Judge, next is
Hi.
case 12. Marshall, come on up.
May I approach, Judge?
All right.
Good morning.
Hi, good morning. How are you?
I'm all right. Hope
Happy
you're doing
Friday.
well.
Good morning, Mr. Marshall. Good morning.
Good morning.
Sir, you're charged with unlawful carrying of a weapon. You're facing up to a year in jail and or a $4,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can and will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, sir.
Thank you, Your Honor. On April 25th, 2025, in Harris County, Texas, a law enforcement officer conducted a traffic stop on a vehicle going 58 in a 40-mile-per-hour zone. The law enforcement officer made contact with the defendant driver and could see in plain view a pistol and a bag of marijuana next to the defendant. The law enforcement officer detained the defendant and found another bag of marijuana in the defendant's jacket pocket.
Okay. Mr. Marshall, I'm going to find that there's probable cause to go forward with the case. While this case is open, I'm warning you not to be in possession of weapons. Do you understand? If I find that you do, if you become a danger to my city, it's not going to go well for you. You just had a case dismissed not a month and a half ago, and now you're here again. Don't be a danger to my city. Do you understand? Yes or no?
Yes, sir.
Because you have a lawyer, we will waive your appearance, but you must stay in touch with him and he will tell you if and when you have to come back to court. Don't pick up any new cases. Can you, does he have a, you said he was driving, right?
Yes, Your Honor.
Can you run him? Does he have a license?
Yes, I'll run it right now.
You are not allowed to drive unless you have a valid Texas driver license and liability insurance in your name. You must maintain car insurance. That is also a condition of your bond. If I find that you're driving without either, likewise, I will arrest you, put you in jail. You understand, sir?
Yes, sir.
Judge's license is eligible.
Wonderful. So we'll have you go sign a reset now. We're going to have bond conditions created for you to sign. Once you sign it, after that, you'll be free to go. So we'll just have you wait in the jury box.
Yeah, I have excuse.
All right, Judge, next is page 2 and 3. Barlow, come on up.
All right.
All right, then have a seat in the jury box behind you.
Good morning, Mr. Barlow. Good morning. So you're charged with 2 cases. You're charged with driving while intoxicated. It's elevated to a Class A misdemeanor because of the high blow. You're facing a year in jail and or a $4,000 fine. Likewise, on the gun case, you're also facing a year. We're going to do probable cause. You have the right to remain silent. Anything you say can and will be used against you. Okay.
Thank you, Your Honor. On May 30th, 2023, an officer was dispatched to an auto accident in Harris County, Texas. A wheel witness on scene advised that they observed the defendant to exit the vehicle and enter the back seat. The defendant, the sole occupant of the vehicle, was asleep in the back seat of the vehicle with the keys in his pants pocket. The officer requested the defendant to exit the vehicle, to which he was observed to have heavily slurred speech, glossy red bloodshot eyes, and unsteady balance upon standing on his feet. The defendant stated he was drinking with friends at a party and arrived in his own vehicle and left on his own. He was unable to perform standard field sobriety tests safely or follow the officer's instructions due to him continuously falling asleep and vomiting. The DIC was read and he was unable to deny or give consent to breath or blood due to his level of intoxication. A blood warrant was then obtained and executed. While conducting an inventory of the vehicle incident to arrest, a black handgun was observed in plain view on the driver's side panel. The blood alcohol level came back to a 0.187.
Mr. Barlow, I'm going to find that there's sufficient probable cause to go forward with the case. I don't know if you have a problem with drugs or alcohol. Now is the time for you to address it if you do. I'm ordering you not to use, and if I find that you do, if you have a problem, you don't address it, I'm going to do it for you, and I promise you're not going to like the way that I do it. Do you understand? You are not to use alcohol, illegal drugs, unprescribed controlled medication. I'm going to test you like crazy to make sure you're not using. Do you understand?
Sir.
You're also, while on bond for this case, not to be in possession of weapons as well. For now, any prior DWIs, and does he have a license? Please.
Good, I'm not seeing any prior DWIs here.
Okay. As with every case, you are not to drive unless you have a valid license and insurance in your name. You must maintain car insurance as well.
His license is open.
Okay, so for now, we're gonna have to go to Victoria Center reset. You will eventually get with Roxanne for your bond conditions. After that, you're free to go. Thank you.
All right, Judge, bottom of page 1, Alborno, right?
No more lawyers?
Not at this moment, Judge. Ms. Martinez?
Good morning, Mr. Albornoz. Sir, you're charged with assault of a family member. You're facing up to a year in jail and or a $4,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, sir.
On August 23rd, 2023, an officer responded to a disturbance/unknown weapon call on Hillcroft Drive in Harris County, Texas. The complaining witness and the defendant were dating and living together, but they recently ended the relationship. On this day, they had a verbal disagreement, and the defendant called her a stupid bitch and a stupid hoe for smoking one of his cigarettes. The complaining witness advised that the defendant kept getting closer to her, so she pushed him away, at which point the defendant slapped her in the face with an open hand and punched her in the face with a closed fist, causing her to have a black eye. The complaining witness advised the defendant, then punched her in the right arm, causing severe visible bruising, dragged her from the living room by her shirt, and kicked her multiple times while she was on the floor. The complaining witness advised the defendant continued by punching her in the ribs and thighs multiple times. The defendant then banged her head against the wall, causing blood from her nose to splatter against the wall. The complaining witness advised the assault caused her pain. The defendant then smashed her phone and prescription glasses against the bedroom door, breaking both items. The complaining witness advised that during the assault, while the defendant was banging her head against the walls, the defendant pushed her so hard that large holes in the living room, hallway, and bedroom walls formed. The officer took pictures of injuries and of the damage.
I want you to know that I'm going to protect every single person, every single thing in my county at all costs. And if I find that you're a danger, I'm going to put you in jail and make your bond so high you'll have patches of hair falling out. Do you understand?
Sir.
You are not to have any contact with the complaining witness in this case. You are not to consume alcohol, illegal drugs, and I'm going to test you like crazy to make sure you're not used. Do you understand? There is a protective order that has been issued in this case. Know every single part of it, because if you violate any of the set conditions, the state can and will file a violation protective order, and that is the capital murder of misdemeanors. You violate conditions on one of those, I can have a hearing to hold you at no bond. Zero bond until this case is over with, and I will do it in a heartbeat to protect my city. Do you understand? What are you doing with yourself these days?
I'm working.
Are you working full time?
Yes, sir.
I see that. It's okay. I want to see what he's doing. You need to understand something, Mr. Albornoz. If I revoke your bond and make it 5, 10, 15,000 and you don't have anyone to bond you out, you will be stuck like Chuck in there until this thing is over. Do you understand? So don't be a danger to my city. I'm going to have you sign a reset with Victoria. You will eventually get with Roxanne for your pretrial conditions, then we'll take a look at your affidavit. Don't worry about conditions, Cole, because I'm going to monitor him and make sure he's not using.
Next judge is page 2.
Yeah.
Avila,
I'm going to make sure he's working.
Diaz,
We need to.
or for Avila.
Yeah, I think it's fine.
So you said Vic Diaz, you said?
Avila.
Page 2, topic 2.
Okay.
Ben?
Okay.
Okay.
I will.
Page 4, Bobo.
You were Mr. Bobo. So you're charged with assault of a family member. You're facing up to a year in jail and or a $4,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can and will be used against you, sir. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, sir.
Thank you, Your Honor. On October 6, 2024, in Harris County, Texas, officers responded to an assault call. The officer met with the complaining witness, who stated that her and the defendant had been dating for 2 years. The complaining witness stated that they got into an argument where the complaining witness attempted to gather her belongings, but the defendant hid her luggage. When the complaining witness tried to get her belongings, the defendant struck the complaining witness in the head 10 to 15 times, causing pain. The law enforcement officer observed the video footage showing the complaining witness get struck by the defendant.
Find that there's sufficient probable cause to go forward with your case. I'm ordering you now as a condition of your bond not to have any contact with the complaining witness in this case. Is there no protective order that has been issued in here?
One of the image, but I didn't see that the money and intro.
I'm gonna do my this.
One has been signed intro.
Okay. I'm gonna deny that. Mr. Bobo, I'm going to enter in what's called a magistrate's order for emergency protection. This is a court order that identifies Ms. Nelson as a protected individual. You cannot commit family violence or an assault against this person. Commit an act in furtherance of an offense under section 42.072 of the Texas Penal Code, which is the stalking statute. You cannot threaten, harass, use another person to communicate a threat or harassing behavior. You cannot be in possession of a weapon or go within 200 feet of where she lives or where she works. Do you understand?
Yes, sir.
If you violate this, the state can and will file additional charges against you, a violation of protective order. It's one of the worst cases you can pick up. I am ordering you while this case is open, not to have any contact with her whatsoever, and not to be in possession of weapons.
Yes, sir.
Do you mind filing that, please? No contact and no weapons.
Yes, Your Honor.
We're going to have you come up here, sign the order for protection. After that, I'm going to get you to Victoria. We will have you sign a reset. After that, I'm going to have you take a seat in the jury box. So we'll get additional bond conditions. Once you sign that, you'll be free to go. And please have a lawyer, sir.
Yes, sir.
Come on.
All right, Judge, next is page 4 and 5. Bustamante, come on up.
Good morning, Mr. Bustamante. You speak English, sir? Sir. So you're charged with terroristic threat of a family or a household member. That allegation kicks it up to a Class A misdemeanor, so you're facing up to a year in jail and or a $4,000 fine. Oh. Oh. He's on bond for a terroristic threat and he's picked up another terroristic threat.
Correct, Your Honor.
They're my kids. My kids.
We are going to do probable cause on the new case. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, sir.
We'll do probably, obviously do probable cause range. There's some other things we want to get into when we actually have a lawyer appointed. But we're happy to do the probable cause range right now.
Is it part of the new case or the old case? Okay.
And the old case.
You have the right to remain silent. Exercise that right. Now is not the time for you to fight this case, Mr. Bustamante. Please.
Judge, on April 25th, 2025 in Harris County, Texas, law enforcement officers were dispatched to a criminal mischief call and made contact with the complaining witness, defendant's son, who stated that the defendant damaged complaining witness's mother's vehicle. That would be the defendant's wife's vehicle. And when complaining witness asked the defendant why he did it, the defendant replied, "I'm going to beat your fucking ass." Complaining witness stated he was in fear for his life due to the defendant being known to be aggressive with family members.
Same complaining witnesses in the first case?
Yes, Your Honor. The complaining witness in the first case is the defendant's daughter. The complaining witness in the second case is the defendant's son.
Mr. Bustamante, I'm going to find that there's sufficient probable cause to go forward with your case on the new case. I ordered you not to pick up any new cases. I told you not to become a danger to my city. You've now picked up a new case, endangering my city. I now am going to revoke your bond. You go into custody. Goes with you.
What in the world is a 16-year-old?
Stop. I will appoint you a lawyer today if you don't have one, but.
He threatened me to kill me.
Yes, thank you.
Then they put me with murders. They threatened me inside of jail? What is that right?
Yeah. He was on the landlord. He was on the homes anyways, right? So it was at 25 or more.
Yeah, it's not
Right. So 5,002. Did he get a PR bond on the first case?
Yeah.
On the second case?
It was a PR bond, then a surety.
On the new case, it's a surety? Or
On the old case, it was a surety.
Yeah, the old case, yeah, who made sure.
next?
Okay, sure, so.
Okay.
All right, Judge, next is page 5-6, Heller.
See, everybody, I told you they'd fix the camera eventually. We're just going to go ahead and stick with Judge Fleischer because he was so late to the party, and frankly, there's not a whole lot going on in other places, so we'll just ride with him for a while.
If you want something else, put either way, put that on, you want so.
All right, good morning, Mr. Ayler. Sir, you're charged with driving while intoxicated. You're facing up to 6 months in jail and or a $2,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. It looks like you're also charged with unlawful carrying of a weapon. On that one, you're facing up to a year and or a $4,000 fine. Okay.
Thank you, Your Honor. On April 27, 2025, in Harris County, Texas, a law enforcement officer observed a vehicle traveling 50 miles per hour in a 30 mile per hour zone via radar and failed to signal at a right turn. A traffic stop was initiated, and upon contact with the defendant, the law enforcement officer observed a handgun on the rear right passenger floorboard, unholstered and later confirmed to be loaded. Law enforcement officer observed glossy eyes, strong odor of alcoholic beverage, and slurred speech from the defendant. The defendant admitted to consuming 3 alcoholic beverages. Standard field sobriety tests were conducted. A 6 out of 6 was recorded on the HGN, a 2 out of 8 on the walk and turn, and a 2 out of 4 on the one-leg stand. The defendant consented to provide breath and blew a .136 and a .141.
Okay, any prior DWIs?
Yes, Your Honor, out of a different county.
Is it open?
No, Your Honor, it was closed in 2014 with 12 months of probation.
Can you run a full NCIC to see how many there are?
Yes, Judge.
Mr. Ayler, I'm going to find that there's sufficient probable cause to go forward with the case. Also, if you can run his license, please. I'm now placing a restriction on you, Mr. Ayler. You are not allowed to drive any vehicle that's not equipped with an ignition interlock on it. If you're caught driving a vehicle that doesn't have an interlock, I will revoke your bond, put you in jail. No more PR bonds. Likewise, you're ordered not to consume alcohol or illegal drugs. You will be randomly tested. I'm sending notice to DPS in Austin. Every single officer in the state will know that if you're driving a vehicle and it doesn't have an interlock, you will be arrested and put into jail. Do you understand?
Judge, it's just the one previous DWI.
Okay, license, what'd you say?
License.
You're also not allowed to drive unless you have a valid license and liability insurance in your name as well. That is a part of your bond conditions. For now, I'm going to have you go to Victoria, sign a reset. You will eventually get with Roxanne for your bond conditions, and after that, you'll be free to go.
It is eligible.
Great. Okay, come on,
CHA?
please.
Okay. Counsel, are you ready? I'll go down. Yes.
Hi.
Judge, next.
Great to see you.
Great to see you as well. Go down, come on up.
Okay.
Good morning, Mr. Godine.
You doing, sir?
Sir, you're charged with driving while intoxicated. You're facing up to 6 months in jail and or a $2,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can and will be used against you, sir.
Thank you, Your Honor. On April 26, 2025, in Harris County, Texas, a law enforcement officer observed a vehicle run a red light and initiated a traffic stop. The law enforcement officer made contact with the defendant, the driver, and observed bloodshot eyes, droopy eyelids, constricted pupils, unbalanced, and the defendant to be talkative and have trouble concentrating. The defendant admitted to running the red light. Standard field sobriety tests were conducted. A 2 out of 6 was reported on the HGN, a 5 out of 8 on the walk and turn, and a 1 out of 4 on the one-leg stand. The defendant estimated 30 seconds passing and what was in reality 72 seconds on the one-leg stand. The defendant admitted to smoking weed earlier. The defendant consented to breath and blew a .00. The defendant consented to drug influence evaluation, and a drug recognition expert believed the defendant to be under the influence of a central nervous system stimulant, a narcotic, an analgesic, and cannabis. Thank you, Your Honor. And the defendant admitted he took oxycodone or narcos and smoked weed. A blood warrant was obtained and executed.
Mr. Godine, I'm going to find that there's sufficient probable cause to go forward to the case. If you have a drug or alcohol problem, now is the time for you to address it. I'm giving you the opportunity now. If I find that becomes a problem while you're on bond, I'm going to revoke your bond. I will put you in jail, and I'm going to address it myself. Oxy is one of the absolute worst things that you could possibly take because you build up such a tolerance to it. You literally put your lungs to sleep if you take too much and you end up dying. I cannot tell you how many people have died from this drug. It's absolutely disgusting. And the maker has been sued repeatedly by how many different states in this country because it's such an addictive thing. Don't use. I'm telling you now, within the next week, I'm going to test you because I want to make sure you're not using. Do you understand?
Sir.
Don't use. You've got a great lawyer here. She will take care of you, but I don't care who you have here. Jesus, you use. It's not going to go well. Do you understand?
Yes, sir.
License, prior DWIs?
The license is eligible.
Okay.
And not seeing any prior DWIs here, Your Honor.
I'm telling you that I've had probably a handful of friends that have died from oxy because they continue to take it, build up that punch and put their lungs to sleep. It's disgusting. Just don't. Do you understand?
Yes, sir.
I don't want you to kill yourself. Life is way too short.
Yes, sir.
You're not allowed to drive unless you also have a valid Texas driver license and liability insurance. Do you understand? Because you have a lawyer, we will waive your appearance, but it is your responsibility to stay in touch with Ms. Barks, and she'll tell you if and when you have to come back to court. Be careful. Don't use. As long as you do, all is well. Come on.
Your Honor.
Thank you, Ms.
This way. All right, Judge, next is, go ahead and sign, please. Page 6, Garza, come on up.
Hey, Lori. You want to chat me what you want? What you got? Good morning, Mr. Garza.
Good morning.
Sir, you're charged with reckless driving. You're facing up to 30 days in jail and or a $500 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can and will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, sir.
Thank you, Your Honor. On April 24th, 2025, in Harris County, Texas, an undercover law enforcement officer observed a vehicle conducting multiple donuts in a parking lot in close proximity to other vehicles and pedestrians. The law enforcement officer maintained visual of the vehicle until another law enforcement officer was able to conduct a traffic stop of the vehicle and detain the defendant. The defendant admitted he was the one driving the vehicle and doing donuts.
Mr. Garza, I'm going to find that there's probable cause to go forward with the case. Does he have a license?
It is eligible, Your Honor.
Okay, I'm ordering you now as a condition of your bond not to participate in these types of activities anymore. Racing, street takeovers, donuts, reckless driving. If I find that you do, first I'm going to put you in jail. The next thing I will take your ability to drive away. Do you understand?
Yes, sir.
How old are you, sir?
17.
You want a court-appointed lawyer?
So was it?
You need a lawyer to represent. Do you know if your family's going to hire you one, or do you want to apply? Okay, so you don't want to apply for a court-appointed lawyer. Okay. I'm going to have you go to Victoria, sign and reset. We'll have you take a seat in the jury box while I get your bond conditions. Don't drive maniacally. Do you understand? You are also not allowed to drive unless you have car insurance in your name as well. If I find that you're doing without it, it's not going to go well. Come on. Come on.
Barlow?
So just,
If not signed.
well, so I guess
I can just file one thing. So you can
say
take Brandon.
wishes to hire a lawyer so that we don't, so we don't.
Bailey says doing it for the gram. Yeah, probably. Everybody is chasing fame and clout, and so few get it. But that's kind of the culture we've built, isn't it? By the way, thank you to everybody out there. We blew past 17,000 subscribers for the channel over the weekend. That's very much appreciated. If you are watching and are not subscribed, I hope I've earned your subscription today, despite our little blip about an hour ago as the power went out for just a moment. Also, links, if you choose to become a channel member, there's a link in the pinned chat comment. Also, towards the top of the chat, you'll find a link to join our newsletter. I encourage you to do so because about the beginning of the month, we're going to start sending out a weekly newsletter. Anyways, back to Judge.
Okay, it's signed on both ends.
Okay. Speed up, Bobo. Come on up.
All right, good morning, Mr. Ramirez.
Good morning, sir.
Sir, you're charged with driving while intoxicated. You're facing up to 6 months in jail and or a $2,000 fine. We're going to do the probable cause. You have the right to remain silent. Anything you say can and will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, sir.
Thank you, Your Honor. On April 27, 2025, in Harris County, Texas, a law enforcement officer was dispatched to a major accident. The law enforcement officer observed a house with damage to the garage and the front of the house. Additionally, a Harris County Constable patrol vehicle was parked in front of another home and was damaged. The law enforcement officer observed the defendant's motor vehicle to have damage as well. The law enforcement officer observed the defendant to match the description given by dispatch and detained the defendant. The law enforcement officer met with a witness who recorded the accident and spotted the defendant as the driver. The law enforcement officer ID'd the defendant by his Texas driver's license. The law enforcement officer observed a strong odor of alcoholic beverage emitting from the defendant's breath, red bloodshot eyes, and slurred speech. The defendant declined to perform standard field sobriety tests. The DIC was read and the defendant agreed to provide a sample. However, due to the defendant's age, the law enforcement officer obtained a blood warrant, which was then executed.
Any prior DWIs?
No, Judge.
License?
License.
Okay, Mr. Ramirez, I'm going to find that there's sufficient probable cause to go forward with the case. I'm ordering you now as a condition of your bond not to consume alcohol, illegal drugs, unprescribed controlled medication. I'm going to randomly test you if I find that you're using. It's not going to go well for you. I will revoke your bond, put you in jail. Do you understand?
Yes, sir.
If you become a danger to my city, I'm going to do everything in my power to protect it. You're not allowed to drive unless you have a valid Texas driver license and liability insurance in your name.
Yes, sir.
How old are you, sir?
18.
Do you have the ability to hire a lawyer?
Might possibly, yes, sir. Not sure. I did just apply to appoint one.
Are you working? What do you do with yourself?
Yes, sir. I do work. I'm an employed full-time cashier at Bunsa within Katy, but the money.
Don't. I just want to know if you're working.
Oh, yes, sir.
All right, good job. So I'm going to appoint your lawyer today.
Thanks, sir.
Don't use. I don't care where you're going, what you're doing. I don't care if it's Jesus asked you to break bread. Don't use. It's not going to go well. Do you understand?
Yes, sir.
All right. I'm going to have you sign a reset with Victoria. We'll have you take your seat in the jury box while we have you sign conditions and find your lawyer.
Okay, thanks, sir.
All right, Judge, next is page 15, Randolph. Come on up.
Back off.
Good morning, Mr. Randolph.
Good morning.
So you're charged with assault, causing bodily injury. You're facing up to a year in jail and our $4,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, sir. All right.
The judge. Judge on.
We're doing, here, there's no reason for you to be looking out there. We're going to do probable cause. We have to find out what happened with the case.
Judge, on April 23rd, 2025, an officer dispatched an assault call and made contact with the complaining witness, and the defendant. The complaining witness stated that he saw the defendant talking to and following a witness, and the witness then started to run away and observed the defendant to chase after the witness. The complaining witness then got in between the defendant and the complaining witness, and the defendant then struck the complaining witness with a closed fist. The complaining witness said he felt pain, and they grabbed the defendant and they proceeded to grapple until security arrived. The witness stated that she did not know the defendant and that her and her friend walked past the defendant on the street. The defendant then began to verbally harass them and started to get verbally aggressive. She asked the defendant to leave them alone, and the defendant continued to refuse to do so, and that she began to walk away and to try and get away from the defendant, but got stuck at the intersection crosswalk. Then corroborated the facts that the complaining witness provided about getting between the two of them.
Mr. Randolph, I'm going to find that there's sufficient probable cause to go forward with the case. I'm ordering you as a condition of your bond not to consume alcohol, illegal drugs, or unprescribed controlled medication. Do you understand? I'm ordering you also now not to be in possession of any weapons, not to have any contact with the complaining witness, and not to go to this part of the street. Do you understand?
Yeah.
Don't be a danger to my city, man. I'm not asking for much.
I'm not in danger. I didn't never know these people, Your Honor. I wasn't out. I need a public defender.
I'll give you one. But I'm telling you now, Mr. Randolph, don't be a danger to my city.
I was never in danger. Just I don't intend to be in danger either.
All I want my streets safe.
It was in danger to me, and that's why I'm showing up today.
I'm going to protect my streets at all costs. You
You
understand?
protect me from these kind of people.
I'm going to have you go to Victoria, sign a reset. After that, I'm
I
going
do
to
need a public defending office, your judge or
I already
lawyer.
told you I was going to give you one. Just really.
I'm really scared for my life because I just did 4 years and I'm going through the same thing again in your courtroom when I did good and I'm going through all the facilities. There was never in a harm's way standing 100 feet away from these people or 200 feet. I was never 100 feet within there.
No. Exercise.
And I'm
the
running
right
from
to
these
stop.
people.
You're going to say something that hurts your case. Just stop.
Yes, sir.
I'm not asking you to say anything. I just want
to also be safe in your community also.
Don't use any dope. Don't use any alcohol.
Never was. I was sober that day. I was sober as can be. No drugs, nothing. Enjoying a beautiful day for my mama's funeral. I don't know these people.
Listen, just I'm gonna have you sign a reset. I'm gonna have you take your seat in the jury. Yo, I'm not talking to you. Once you sign the reset, just take a seat in the jury box. I'm gonna find your lawyer, but we need you to sign conditions. Don't leave until you sign the bond conditions.
Yeah.
Come on.
All right, Judge, next is page 16. Reed, come on up.
Hey guys, stay. You're gonna have to give her the location on the street so that she knows. All right, good morning, Miss Reed.
Good morning.
Ma'am, you're charged with theft. You're facing up to 6 months in jail and or a $2,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, ma'am.
Thank you, Your Honor. On April 26, 2025, a law enforcement officer was dispatched to a Target store in reference to a shoplifter in Harris County, Texas. The law enforcement officer spoke with the complaining witness, the loss prevention officer, who stated that the defendant was observed on videotape obtaining items without payment. The defendant was observed on camera grabbing multiple items of merchandise, placing them in her backpack, and bypassing all points of sale without attempting to pay for the items. The complaining witness stopped the defendant after they had passed all points of sale, and the defendant was ID'd by name and date of birth. The total value of the items taken was $119.97.
The co-defendant?
Let me check.
Ms. Reed, I'm going to find that there's sufficient probable cause to go forward with the case. I'm ordering you now as a condition of your bond not to go to any Target for any reason. Do you understand?
Yes, sir.
If I find that you do, I will revoke your bond, put you in jail. No more PR bonds. Likewise, don't pick up any new cases. Do you have the ability to hire a lawyer, ma'am? Okay, we can have you fill. Did she fill one out?
Yes, Jade Reed?
Yeah. Okay, you're currently in school?
Yes, sir.
Are you in school full-time?
Yes.
Okay, I'm gonna appoint you a lawyer, ma'am. If you want to go to Victoria, we'll have you sign a reset. After that, we'll have you take your seat in the jury box while we find you a lawyer, and then we'll have you sign bond conditions as well, ma'am. Thanks. So no going to any Target, please.
Yes, Your Honor. And there are no co-defendants to my knowledge.
All right, Judge, next is page 17. Reyes, come on up.
Good morning, Ms. Reyes. You were charged with driving while intoxicated. You're facing up to 6 months in jail and a $2,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. The right to have an attorney present. If you cannot afford one, one will be appointed to you, ma'am.
Thank you, Your Honor. On April 25th, 2025, a law enforcement officer was dispatched regarding a DWI investigation in Harris County, Texas. The law enforcement officer who conducted the traffic stop stated he observed the motor vehicle traveling the wrong way down Commerce Street. The law enforcement officer stated to the investigating officer that he observed red glossy eyes. The other law enforcement officer arrived on scene and observed bloodshot glossy eyes. The defendant admitted to drinking small margarita sample-sized drinks. The defendant stated she did not know she was traveling the wrong way down the street. Standard field sobriety tests were conducted. A 6 out of 6 was recorded on the HGN, a 2 out of 8 on the walk and turn, and a 3 out of 4 on the one-leg stand. The defendant consented to a roadside preliminary breath test yielding a 0.12. The DIC was read, and the defendant agreed to provide a breath sample for the breath test strip reading a 0.086 and a 0.088.
Okay. Ms. Reyes, I'm going to find that there's sufficient probable cause to go forward with the case. I'm ordering you now as a condition of your bond not to consume alcohol, illegal drugs, unprescribed controlled medication. I'm going to test you. If I find that you're using, I will put you in jail. You understand, man? Any prior DWIs?
No prior DWIs.
License?
Eligible.
Okay. You are not allowed to drive unless you have a valid license and insurance in your name. You understand? That is also a condition of your bond. I will appoint your lawyer today. So what we'll have you do now is I'm going to have you head on over to Victoria, sign a reset. We'll have you take a seat in the jury box. I'm going to get your bond conditions, we'll have you sign it, and we'll have you speak to a lawyer here momentarily, ma'am. Okay, please.
Next judge is page 20, Taylor Marcus.
Aaron Smith, Aaron Jones Smith, come on up.
Taylor.
So, Michael,
Said he has a video.
who has to be? I know, but it looks like he's appointed to Jessica Taylor, who might be the co-defendant in this case.
It is a video.
Okay.
Yes, Your Honor.
Okay, well, I'll do yours after, I guess. So you are Marcus Taylor. Mr. Taylor, you're charged with assault, bodily injury. You're facing up to a year in jail and or a $4,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, sir.
Thank you, Your Honor. On April 27, 2025, in Harris County, Texas, law enforcement officers were dispatched to a disturbance/unknown weapon call. The law enforcement officer met with the complaining witness, who stated he is an employee of the state veterans home on the nursing staff.
John Garza.
The complaining witness states that the defendant is unwelcome at the facility and has been asked to leave on multiple occasions, and the defendant has refused to do so. The complaining witness stated the defendant was attempting to have his grandfather sign power of attorney paperwork. However, nurses intervened due to the grandfather being diagnosed with dementia. The complaining witness states that the defendant used force to remove the complaining witness from the grandfather's room by pushing the complaining witness on the chest with his hands. The complaining witness stated he felt pain. The complaining witness positively ID'd the defendant. Law enforcement officers detained the defendant without incident.
Okay. Mr. Taylor, I'm going to find that there's sufficient probable cause to go forward with the case. I'm ordering you now as a condition of your bond not to go back to this location. Do you understand? If you violate these conditions, I will revoke your bond, put you in jail. No more PR bonds. You were also ordered as a condition not to be in possession of any weapons as well. We are going to reset your case to give you time to hire a lawyer. So I will have you go to Victoria, sign a recess. After that, we'll have you take a seat in the jury box while we get your bond conditions. We'll have you sign it, and after that, you'll be free to go.
This is at the David Church.
Okay, please. Okay, Michael, are you ready? Jessica
Yes, Your
Taylor,
Honor.
come up. You are on bond for murder and you've now picked up an assault case. You're facing up to a year in jail and or a $4,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can and will be used against you.
Thank you, Your Honor. On April 27th, 2025, in Harris County, Texas, officers were dispatched to a disturbance/unknown weapon call. The complaining witness stated she is part of the nursing staff and that the defendant has been asked to leave on multiple occasions and refuses to do so. The complaining witness stated that the defendant was attempting to get her grandfather to sign over power of attorney to her, but the staff would not allow this due to the grandfather being diagnosed with dementia. The complaining witness stated that the defendant used force on the complaining witness to get her to leave the grandfather's room. The complaining witness states that the defendant put her hands on the complaining witness's face and pushed it back. The defendant was positively identified by the complaining witness and her Texas ID number.
You say that there was any pain? She pushed in the face. This is an assault, right? There has to be some kind of injury or pain.
She did state that she felt pain in the dim summary.
Okay. Ms. Taylor, I'm going to find that there's sufficient probable cause to go forward with the case. Now, you're saying there's a bond violation in this case?
Yes, Judge, it's in the.
Michael, have you seen this? And how did you already get appointed to this case?
Your Honor, I was appointed sometime very recently on this case. I received a text. I don't know what day it was, but I received.
It looks like it was the 29th, which was Tuesday. But how was he appointed a lawyer?
I'm thinking when she was in the holdover.
No. How is she, I mean, I don't understand. Well, regardless, I guess I'm glad that you're appointed because right now she's got bond violations. She was ordered by the magistrate.
I wasn't aware of that, Judge.
I'm sorry?
I wasn't aware of a BVR in this case. I actually have another BVR today before the court.
I know that, yeah, we got you. We'll deal with that one next, but you're on bond for murder. You were ordered by the magistrate to have a GPS monitor. You have violated those conditions. Unacceptable. I'm revoking your bond. She goes with you. No.
Your Honor, if I may.
Yeah.
Your Honor, she just was released because I met her in the holdover earlier this week, and she could not have been out of jail more than a day, 2 at the most. Would the court allow her to leave right now to get the device?
No. Did she not get the device?
Judge, there was a conflict, that's why the DVR was submitted, felony, so the magistrate ordered bond conditions, but the curfew times were not aligning with the felony condition.
So what? I mean, you still have to abide by the conditions. I mean, what did they say the conditions were?
I have the paper up right there.
I'm not asking you to say anything, Ms. Taylor. The only thing I want is I want my city protected. You're on bond for this serious case, and now you picked up an assault. I mean, you were ordered to have certain conditions. You must abide by these conditions.
And Your Honor,
She received conditions of bond on April 28th, 2025 that ordered a GPS device with a curfew of 7 p.m. to 7 a.m. On May 1st, she had an unapproved enter at 7:52 p.m. and then left again at 8:51 until basically 9 o'clock at night.
Yes, Judge, and on the felony conditions, I'm looking at them right now, curfew is from 12 a.m. to 6 a.m. So that's where it's conflicting. So the magistrate ordered from 7 p.m. to 7 a.m. and on felony, their curfew was 12 a.m. to 6 a.m.
I mean, she still has to follow conditions, right? There may be conflicting, but you know, you abide by the conditions, and then you come to court and you ask to, do something or maybe make them align, but you just don't do whatever you want to do and think, okay, nothing's going to happen. You're on bond for 2 serious cases.
Your Honor, if I may again,
Sure.
this is a brand new case. Could the court admonish her? Because the amount of time, I understand that.
Michael, she's on bond for murder. She's lucky to even have a bond, and now she picks up an assault. She's ordered to have a curfew, and she's just doing whatever the hell she wants to do.
In this case, Judge, that's before your court. This is a brand new case, and this is her first time having any issues while on your bond, Judge. Would the court be willing to admonish her not to leave her home even for short periods of time?
I don't know, Mikey. I don't know.
And my assumption is we're gonna reach out to Melanie. My assumption is there's a BVR call for that too, so I don't know what her comment looks like, but.
I don't know, Michael. I'm going to stew on it for a while. You
Yeah,
want to
sure.
talk about your other BVR? Or wait, hold on a second. Sorry, let me just finish with the arraignments. Give me 2 seconds and then we're almost
No
done.
problem, Judge.
Next one, Judge, is page 2, Avila, Diaz.
And do another Spanish speaking on the answer.
Judge, those bond conditions, do we want to do no returning to?
No. You don't need to do anything because I'm going to have her monitored like.
Yes, sir.
Yeah, we'll get to it in a second. Come up. You are Marvin Avila Diaz.
Yes, Marvin Avila Diaz. Yes, sir.
You were charged with assault of a family member. You are facing up to a year in jail and or a $4,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one will be appointed for you, sir.
Thank you, Your Honor. On April 26, 2025, in Harris County, Texas, officers were dispatched to a disturbance call. Officers met with the complaining witness who stated that the defendant and him are in a dating relationship. The complaining witness stated that they had just dropped friends off and started to argue about the vehicle they were driving. The argument became physical, and the defendant struck the complaining witness in the face with a closed fist multiple times, causing bleeding and pain. The officers observed the complaining witness to have dried blood on his face. Take a closer look here, Judge.
Mr. Avila Diaz, I'm going to find that there's sufficient probable cause to go forward with the case. Any alcohol or anything a factor? I am ordering you now as a condition of your bond not to have any contact with the complaining witness in this case, not to be in possession of weapons. Mr. Avila, I don't know what your immigration status is, but if you're not in this country with permission and you go to jail and immigration finds you, it's very possible they put a detainer on you and you will be stuck in custody until this case is over with, and then you get shipped to immigration. Do you understand? Yes, sir. Get no more warnings. Mr. Avila, I'm going to protect my city at all costs, and if that means putting you in jail, I will do it in a moment's notice.
Judge, the law enforcement officer observes the defendant to be in the vehicle, but to be in the front right passenger side. It does not indicate that alcohol was a factor.
There is a protective order that has been issued in this case. Yet to know it. If you do something to violate this protective order, the state can and will probably file a violation of protective order against you. And that is one of the worst cases that you can make up.
Entonces no hablas con él.
Are you working at this time?
¿Estás trabajando en este momento? No, sir.
Are you in school full
¿Estás
time?
estudiando? Ya terminé. I completed it.
It's time for you to do something. You need to either work full time or you need to be in school full time, but doing nothing, it's not going to work. That is also a condition of law. I will appoint you a lawyer today, but I'm going to bring you back in several weeks to see what you have done to get a full-time job. If it's nothing,
Voy a averiguar qué estás haciendo para conseguir.
do you understand?
¿Entendió? Conteste al juez.
I'm going to have you sign a receipt with Victoria. After that, I'm going to have you take your seat in the jury box while we create your bond conditions.
Siempre vas a...
All right, Judge, the next Spanish arraignment is page 7, Hernandez. No, Enriquez. Rivera.
So obviously we are running a little bit longer today. I can go for a little while longer, so we'll keep going with Judge for just a little bit.
All right, that's the last Spanish arraignment, page 22, Yepes.
Yepes Ovidio, come up. Mr. Yepes Ovidio, you are charged with tampering with the government's record. You're facing up to a year in jail and or a $4,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, sir.
On April 26, 2024, a law enforcement officer was on patrol in Harris County, Texas, when he observed a motor vehicle going 82 miles per hour in a 65 mile per hour zone. A traffic stop was conducted. The law enforcement officer ran the plates and came back with no records. The defendant stated he did not speak English. The law enforcement officer discovered a case report was made on March 27, 2025, with the same vehicle in question, displaying a paper plate, but with the matching VIN number of the vehicle, with no record shown on the vehicle. A Spanish-speaking law enforcement officer was informed by the defendant that the defendant purchased the car 3 days ago on Facebook Marketplace and was given that paper dealer temporary tag. The defendant was questioned about the March 27th incident, to which the defendant admitted he was in possession of the vehicle during that incident as well. The defendant then admitted to operating a motor vehicle with a fake temporary tag on the vehicle. The defendant further informed the law enforcement officer that he purchased the plates off Facebook Marketplace and met up with a guy 3 days prior to the incident in a Walmart parking lot to receive the fake plates. The defendant was positively identified by his citizenship card from Peru and Venezuela.
License? Mr. Yepes Ovidio, I'm going to find that there's sufficient probable cause to go forward with your case. If you do not have a Texas driver license and liability insurance, you are not allowed to drive, and that is a condition of your bond. If I find that you violate these conditions, I will put you in jail. I don't know what your immigration status is, but if you're not in this country with permission and you go to jail, immigration finds you because they sweep it hourly. They will put a detainer on you and you will be stuck like Chuck in there until this case is over with, and then you get shipped off to immigration. Do you understand?
Judge, there's no driver's license information populating for the.
This is an affidavit. This is a promise you're going to make to me that you're not going to drive.
Estás diciendo que vas a...
I don't care what your excuse is. I don't care what your justification is. If you drive, it's
Justificación.
really not going to go well for you.
No te va a ir bien.
Do you understand?
¿Entendido?
Okay.
Sí, señor.
We're gonna have you come up here, swear to us that you're not gonna
Firmar
drive.
ese documento
After
jurando
that,
que
I'll
no
have you
vas a
take a seat in
firmar.
the jury box. I'll
Y
leave
después
all
vas a
conditions
tomar un
ready.
asiento.
Have you sign it.
Y vas a firmar los dos documentos.
Dick, anyone else?
Council was here this morning to do a plea. Want to do that?
Yes, may I approach on this?
All right, come on.
Page 13.
Good morning, Your Honor.
Good morning, Mr. Blaine. How are you?
I'm doing well. How are you, sir?
Friday.
Thank goodness. Yes, Your Honor. No, Your Honor, speak up loud enough for me to hear
Good
you.
morning, Mr. Melchor. You're charged with driving while intoxicated. You have worked out an agreement. They're offering you 3 days in jail with credit for the 1 day that you've done. You need to understand that after today, this charge will go on your record. It's going to be there for the rest of your life. If you ever get pulled over, which is going to happen, an officer is going to look up your record. If they see that you have a prior DWI and they roll up to your window and they smell alcohol or dope, it's probably not going to go well for you. So what we're doing today, from now on, is a minimum of 30 days in jail. Not to mention a $6,000 supervisory fee. And if you don't pay it, every $100 you owe, you sit 1 day in jail. You understand?
Yes, sir.
You're giving up the right to a trial, the right to compel witnesses to testify on your behalf, confront and cross-examine your accusers. If you're not a citizen, there are possible immigration consequences. You can be deported, excluded from the country, denied naturalization. You give up the right to appeal. So once you accept this agreement, there's no turning back. This is what you want to do.
Yes, sir.
How do you plead to the offense of driving while intoxicated? Guilty or not guilty? I'm going to find you guilty. I'm going to sentence you to 3 days in jail. I'll give you credit for the 1 day that you've done. I'm going to suspend your license for 180 days, sir. Do not drive until you get a license. Good luck to you.
Thank you, Judge. Maybe we be excused.
Mr. Clay, does he work? What do you do for a living, sir? What kind of money do you make a month?
He makes about $1,400 a month. I've had the conversation with him. He has about $200 left over at the end of the month.
There's a $3,000 fee that would normally apply. I'm going to waive it for you now, but you pick up another one, get ready. It's a $6,000 fee. Do you understand? All right.
Thank you. Thank you, Judge.
All right, Mr. Clay. Come on.
Judge?
Yeah.
Judge, I've got 4 new fugitive appointments today.
Okay.
You want to start there with?
Yeah, so there's going to be 2, Judge, where I'm going to be entering a pre-signed waiver. It's going to be for Bushnell and for DeRuin.
Okay.
And I went ahead and gave, hold on. Yep. Right.
Bushnell and what was the other one?
And DeRuin, Tara DeRuin. I don't know if I'm pronouncing that accurately, but right this court.
It's about the next 2.
And then Johnson, hold on.
So Tiffany Johnson, Judge, she would like a bond. She's wanted for larceny out of Louisiana.
We'll have to talk to her. I mean, so I will bring her out and then, if you want both of them out, let's do them both at this, or did you, the other one as well?
The other one, Judge, Yolanda Swift is currently in medical, so we're just gonna keep her waiver for now and roll her to next week.
Okay, yeah, for sure. Okay, Lori, you ready? Holman, come up.
No, he's in jail, Judge.
Oh, she's in jail. Oh. What do you want to do?
You just need to revoke the, I guess, raise the bonds, or she's on bond on the new evading case.
Yeah, okay. I'll whatever you want, Lori, you know?
All right, I'll just reset her the next week.
Okay, you got it.
Thank you.
What day you want?
The 8th.
You hear that, Dick?
On who?
Holman.
Oh, yes.
Yeah, okay, you're good. You, okay. All right, Maria, you ready? Yes, ma'am. Good morning.
Judge, I'm approaching on Victor Jesus Rauda Lopez. And he's got a bond violation report, Your Honor.
Page 10.
Is he here?
He's here, Judge. He's in the jury box.
Speak English?
Yes, he does.
Come up. Come up.
Answer yes or no, sir.
Did you get your GPS device?
Oh, yeah.
Okay. I'm revoking your bond. I ordered you to get a GPS device. You didn't get it. Okay, goes with you. Sorry, Maria. All right. We're gonna keep you. The bond right now is, oh God, it's 5,000 now.
I already paid the half.
1,001.
Yeah.
We'll just raise it up 1,001.
6,000.
It's 5,000 now,
Right.
so I'll just do 6,001.
Okay, Judge. 6,000.
So if he bonds out,
Yes, Judge.
we'll get it.
Oh, Judge,
Someone
I have, I was assigned a new case
Okay.
because I was appointed about 2.5 weeks ago to 3 previous cases that he's got. And my client is in custody. He's got an immigration hold. He does not have any bond set.
What's the last name?
Manuel Cooch, C-O-C-C-U-Z. And he's got 2 felonies pending, Judge.
Just file this while he's in custody?
Sure.
File this while he's in custody?
Yes. Yes.
So it looks like they found, that's so weird. They found probable cause on it, but they didn't put a bond on it. Right? No, it's weird. I'll set it at, the other ones are at 10,004. I guess I'll just match those.
Yes, Judge.
You know, it really doesn't matter because he's not made bond on the felony or any of the other cases. So
He's
just,
got an immigration hold, Judge.
okay, so we'll just set it at the
I'll
same.
get a reset, Judge. Thank you.
So 10,004, what the other ones are set at?
Reapproach, Judge?
Yeah.
This is on the tip, Judge.
Johnson, you said, right?
Yes, Judge.
All right, good morning, Ms. Johnson. So it looks like you are wanted out of the state of Louisiana for a larceny. It's a misdemeanor, am I right?
Yes, Your Honor.
Okay. Your lawyer's asking for me to set you a bond. I don't know. I need to know more about you. My primary concern, number one, are you going to go back to Louisiana if we give you a bond? Number two, are you going to leave a wake of destruction? Because that's what we don't want. We don't want you to be danger if you're danger, you know. Well, I know that you're going to tell me it's little bunnies jumping in the woods. Everybody does, right? But how you look on paper really tells me who you are.
Your Honor, the demanding jurisdiction requested no bond because the demanding jurisdiction showed that she is also wanted for failure to appear for a DWI, and the FTA was issued out from Caddo Parish on July 21st, 2022, but then she picked up this larceny within the last couple of months this year. While that was an FTA, state requests that there's sufficient bail be set for the fugitive to be returned to the demanding jurisdiction. State requests a $10,000 bond because of the fact that it's a 3-year-old FTA. On top
The case is 3 years old.
No. The other.
The DWI.
Pending, right. She also is wanted for a DWI out of the same parish, but this specific fugitive case is for the larceny. I'm just highlighting the reasons for the higher bail. It's because the older case was 3 years.
See what I mean? That's what I'm saying, you know? Yeah, I know what you're going to tell me, but paper tells me another thing. And that's a big problem. The DWI has been open for 3 years. Now, the only reason we have you is so are you okay with the bond though?
Okay with a bond, just a sufficient bond that she return herself, Your Honor.
Okay.
Yes.
Judge, we wouldn't be opposed to 10,000 if you could set it at that.
Okay, I want you to understand that I don't play games.
Yes, sir.
I'm not going to do this repeatedly.
Yes, sir.
I can set you a bond now, but if you don't go, I'm going to revoke this bond. I will set it at 0. And this time I'm going to hold you until Louisiana comes and gets you. And we're not going to do this again. You have one chance to make it right. We give you 2 weeks from the date of your release to go turn yourself into Louisiana. You must turn yourself in. I'm gonna go do this, I'm gonna hire a lawyer, I'm gonna try to get a bond, no.
Just go turn myself.
Go turn yourself in. The other thing I'm gonna tell you is that Murphy's Law, you know, what can happen will happen. Don't wait until the last day. You know what, I'm gonna go turn myself in now. I don't care if you car trouble, abducted by aliens, don't matter. As soon as you get out, I would go, because that's a lot of money that someone else is toning up for you to get out. Do you understand? All right.
So I just wanted to highlight, and obviously the court set the bond, I'm not disputing that, but just because there have been 2 other fugitives from Caddo Parish that have waived, and I have 6 total from Louisiana. I imagine the transport is going to be soon. So regarding financial capabilities on restoring the bond when returned to Louisiana.
So let them know, you know, what he's trying to tell you basically is that because Louisiana, we have so many people in our jails from Louisiana, we have buses coming 1 to 2 times a week to shuffle in people from and to Louisiana. So if you were to waive within the next couple of days, they'll probably have you back in Louisiana, as opposed to someone dropping 10,000. You said 10,000?
Marcus Taylor? So yes.
As opposed to someone dropping 10,000 to get you out to go turn yourself in within the next 2 weeks. It's up to you. I'm just letting you know what it is, and then you guys can decide what you want to do. Has she waived already?
She's waived. That's why I can stand down if you want to talk to her.
Once, because you have already waived, so we give them a certain amount of time to come pick you up. If they don't come get you within that time, we release you. Once, if you want to post bond, you have to withdraw that waiver, and you lose all the time that you've accrued toward that. I'll let it explain to you, and you guys tell me what you want to do.
Yes, Judge. All right. And Judge, I guess we need to have Bushnell and DeRoyan brought out as well for their pre-signed waivers.
Just enter in the pre-signed waivers. Unless you don't want them to come out to enter, then
I don't care. Just have them sign it and get it. Yeah.
Well, they don't really need to sign, pre-sign.
And just explain to them if they have a problem, or if they don't believe you, or they're giving you a hard time, just let me know. No problem.
Okay, thank you, Judge.
Okay, Ms. Hall. Hey. Thanks. Did you get it done? Tell me you did.
I needed to speak. Pretrial needs an order for you to sign. They're gonna put it in the queue so I can get it off to Genetech in Sarasota, Florida. They're requiring that for me to set an appointment. That's why.
Genetech.
Sorry. Quest Diagnostics, Genetech. I'm sorry, that's another place I'm having a problem with. It was something yesterday.
Okay, I'll sign it now.
He can set it up, the appointment immediately as soon as I get that fax to them.
I'll give it to you now.
And Judge, because client is not here.
Right. And you have to wait. Yeah, wait a second.
Thank you, Judge.
Did you put it in the queue already or no, Roxanne?
No, I'm.
She needed an okay, Judge.
You ready?
Hi, good morning, Judge. How are you? I'm
Happy Friday.
approaching off docket on the trial case,
Okay.
and the cause number is 2545831. And the state has filed dismissal, Judge. I was just approaching on it.
Okay, I'll sign it.
Okay, thank you. Good seeing you, Judge.
Morning, ma'am. Approach.
Morning.
So I'm here on Mitchell Estrada. Gary Tabachny said he spoke to you yesterday on the
Yeah.
phone.
Do you have the cause number?
No, number in Harris County.
No, but for the other case in court.
It's, they're temporary case numbers, some of this.
I know, but the cause number for the court 11 case, because that'll help us pull it up. But that'll work too. What is this?
I have it spent as 030-604-31. I'm glad Gary spoke to you because he told me.
Blaze, I need your help real quick.
Absolutely, Your Honor.
Can I give you a call? Oh, she pled already?
Not that I'm aware of. On what case are you looking?
Is it Mitchell Estrada?
Yes.
Oh, I thought she had an open DWI. She only has these two out of county.
Two in Lee County, she has no cases here.
Okay. Can I give you a cause number?
Is this Michelle Estrada?
Mitchell, yeah.
Yes, I see that.
So she has 2 out of county cases from Lee County. They're asking for a bond to be set so that she can bond out and go back to Lee County. Because otherwise, essentially, whenever you get picked up in Harris County for a case that's out of county, Harris County holds you here for 10 days. And at that point, if the out of county doesn't come get you, I give them a PR bond.
Is there not a, so that's where I guess my confusion is.
She's been in custody. The hold was placed on the 29th. So she must have been arrested here this past Tuesday. And at that point, Harris County told Lee County, hey, we got your person. So Lee County puts the hold.
I'm trying to figure out, so we don't have any charges. Correct.
You do not.
Yeah, it looks like she's got taken out Class Cs. I mean, that's however you do it, Judge. What do you mean?
She has a bail jumping, and I wanted to just run it by you guys and see. One is a bail jumping and another one is a PCS 1 to 4.
Can I talk to David real quick? I think it's also legit. Yeah.
I've not, probably in the entire time I've had this, we've only had this one other time where it's been an issue like this, where we've had someone come and ask for a bond on an out of county case. So I want to make sure that, I guess, everybody involved is.
Understand. It was really, I got a text this morning. Is anyone in state court? I said, yes, I am.
I mean, I'm not, do we have her?
No, because it's a temporary case number. It's not even a court filing.
The thing is that we're not going to get her here until the 10th day pops up. So she's basically just sitting in a holding cell in 1200 Baker until. So what happens if we set you a bond now, you have to go let her know that the bond has been set. She has to make it as soon as she gets out. She has to go turn herself in Lee County. Because otherwise she's just not going to know. They want a bond set so she doesn't sit there for the next 10 days or 8 days.
But the issue with this one, and this is largely outside of the DA's office role in the out of county. For this
No,
one.
but I wanted to still be,
I know, but the issue with this one is equivalent to whenever I request the interstate compact agreement to be entered, is we're largely divorced from that proceeding, and the hold is placed with the sheriff's office. So they communicate with the demanding jurisdiction. If anything's going to happen, it's going to be with their jurisdiction and our sheriff's office. So for the most part, there's no active matter in this court to be contested directly. And like, there's nothing that can be.
Set her a bond.
But there's no case to set a bond to. That's my point. Is right now, there's nothing filed. There's no case number to enter in filings for. So it's like the interstate compact agreement. If somebody asks to.
Do you hear that? So there's no.
Because sometimes they do create a case. That does happen. I've seen it before. You've seen it before.
Basically, what he's saying is until the 10th day, no case number is created for me to attach a bond to.
No cause number.
Right. So there's nothing to be filed because there's nothing to be entered into. So it's filing documents for a case that doesn't exist. For the hold itself, there's numerous reasons the hold can be created without a case being created. And this is just one of those administrative mechanisms that happen between.
There has to be a way that we can give a bond or a PR bond or some way to release.
Right. But typically, and this is largely where I have to kind of take a step back, but if it's the demanding county that's wanting them, that's where the conversation should be, because they're the ones that want.
Have you reached out to Lee County yet? And I forgot to ask this Gary yesterday.
I was just told to come by about an hour ago.
Because it'd be the equivalent of if there's an out-of-state jurisdiction that withdraws their hold or their warrant, is I would ultimately
Is there a way that I can
case.
slip bond?
On a temporary case?
Do me this. Give me a second. Let me reach out to admin to see what more we can do.
Oh, in terms of if the clerk's office, if that's the one, and that's again.
Yeah, can you give me, let me kind of thin it out a little bit, help the lawyers that are waiting. And then, because it's going to take more time for me to reach out to admin to see what I can do.
Got it. I'll hang out.
Yeah, just give me, and I'm sorry that you have to wait. Do you want to go, leave me your cell phone, and then I can text you so you don't have to wait, and then you can always Zoom? So we don't have to just sit and wait?
Do that.
Yeah.
Sorry.
I mean, I'm going to try as much as I can.
No, I appreciate it.
You know?
I appreciate it. I'll be fellow. Morning, Judge. Stephen Davis. We're on a PR bond on this case, Judge.
Okay.
He had a arraignment date maybe a month or so ago, I believe. He had missed his court date. You had given a.
Morning, Mr. Davis.
That was on bond.
How's jail?
Not good.
Right, it's not supposed to be.
No.
Problem is when you don't show up, this is what happens, right? And when you repeatedly don't show up, therein lies an even bigger problem, because I know if I give you a PR bond, what's going to happen? History dictates. And therein lies the problem, because we give everyone, well, not everyone, but nearly everyone, a PR bond.
Yes.
But you got to show up. How many times has he failed to appear?
I believe it's just one time, from my understanding.
No. No.
And so part of the
He
reason,
was first given a general order bond in March, failed to appear for his arraignment. Then he gets rearrested. We give him a PR bond in April, and then again, fails to appear again. And that's why we have him. So it's been 2 times.
Friday, it was wasted from the Friday.
and Judge, part of the reason why I'm asking for a PR bond, I've talked to the state, who does have some mental health diagnosis history. He is bipolar, schizophrenia. They have agreed to allow him to go to Harris Center.
So that's interesting. The feed from Judge has frozen, but you can tell that it's still a live feed because if you look at the guy who zoomed in at the bottom, he's still moving. I've not seen this from them before. We'll give it a second and see if it comes back. This was going to be the last case I was going to cover anyways. So we'll give it just a second. Yeah, we're confused too, buddy. Well, there you go. He's off air. All right. Well, assuming he comes back, we'll have the full feed, the full docket for channel members later today. If not, we'll post what we got, obviously, and that'll be there for you as well. I hope you all had fun today. Again, apologies for the little glitch that we had in the middle of the stream there. But luckily, it wasn't like a couple of weeks ago when we had power out for a long time. This was just a quick blip. And yeah. So I have a really busy weekend, a lot of things that I want to do for the channel here. Hopefully I can get to it, but I've got other business stuff as well. So if you're a person of faith and you pray for time for me because I'm going to need it this weekend. There's a lot to do. Anywho, go on about your business. Have yourself a great Friday and a great weekend. It was a pleasure, as always, to have you all here this week. We'll be back Monday, 10 a.m. Eastern, 7 a.m. Pacific. Take care. God bless.